the correct presentation. Hi. Okay. See if this thing is working today. So you can send any. Would you like a microphone? Can I use this one? You can use this one, or I can give you a lapel. He's so fancy. Yes. It's just tested?
Yes. All set.
Recording. And I think everyone just turned up.
Jonathan is just parking his car.
Yeah. So I think we should start. Yeah.
So good morning, everyone. I'm very pleased to be here and to pack together the introduction to the UNCITRAL Africa Days and the presentation on the investor-state dispute settlement reform that is taking place. It's an update because many of you are well aware, as I could see yesterday, but it's an update of where we are at, how we're working, and what we expect in the coming sessions of the working group. So usually I start with excellencies, dear Mr. Ambassador, Mr. Minister, but here I'm very, very pleased to be able to say dear Martin, dear Jonathan, and dear Emmanuel. Thanks very much for the opportunity to organize jointly 4 of the flagship events of the UNCITRAL Africa Days. We launched this initiative last year for Africa after the commission was chaired by the ambassador of Ghana, who said, why do we have UNCITRAL Days for Asia and the Pacific? And why do we have UNCITRAL Days for Latin America and the Caribbean? And why don't we have them for Africa? So we said, of course. So we launched in May of this year in Accra with the hosted by the Ministry of Foreign Affairs and supported by the European Union. We launched a series of academic events in the African continent. The way we organize these Africa Days, or these UNCITRAL Days in general, is that we get in touch with universities, or universities get in touch with us. We work together around the program. We support in whatever way is needed. And but we give a lot of flexibility in the sense that if you want to have it in person, if you want to have it online, if you want to have 1 event, 2 events, 4, as is the case with the Mandela Institute, you can do it. And we generally try to have a theme for the year. So this year we focused on the African Continental Free Trade Agreement, and particularly on 2 protocols that are relevant to the work we do in UNCITRAL. One is the investment protocol, of course, and the other one is the digital trade, or the e-commerce protocol. So we wanted to have this as the frame of our UNCITRAL Days for Africa. So we looked at how we in UNCITRAL, with the texts and the instruments, the conventions and other model laws we produce, how we can provide the legal infrastructure, because we're not working at the trade negotiations level where we are working on reducing barriers to free flows of trade or negotiating on tariffs. But what we do is really the legal infrastructure that is needed to make sure that when you have agreed that trade can flow, it can also flow in reality, in practice, on the legal ground, meaning that the way you deal with company registration, with the company insolvency, with the contracts, with the trade documents, that it is harmonized and that it can work with that jurisdiction can work with one another, and that the way you negotiate and you agree on some contractual provisions, or the way the legal system recognizes contractual provisions in one country is also harmonized or compatible or interoperable, as we say nowadays, with the legal system of other countries. So that's basically what we do. And we believe that it's this legal infrastructure that then allows you to have a meaningful regional or international negotiation on trade. If you don't have that infrastructure, you're very much at a disadvantage because you're going to be imposed the infrastructure of others. So that's the way, for example, during many years, I've considered that investment should be negotiated. You should have a very strong domestic framework for international, for foreign investment before you can, in a meaningful way, go and negotiate bilaterally or regionally or multilaterally on investment. So having said that, this is really with that in mind that we put together this year's Africa Days. We had a number of universities from different regions who have lined up, and we were very, very happy to have the Mandela Institute join this series. It's taking place concurrently with the LAC Days, the Latin America Days, and the Asia Pacific Days. So everyone in the academic world that is interested in UNCITRAL texts or UNCITRAL or international trade law more broadly is currently actively holding and organizing webinars, seminars, workshops, and the like. So hence my gratitude to the Mandela Institute, and also a call to those young and maybe less young academics that I'm meeting here to do the same thing in your universities. We had a very nice, two very nice events in Sierra Leone. We have one that is starting in Togo. We have one next week in Senegal. We have just had one in Kenya. So you pick it up. It's really for you to tell us that you're interested in doing it, and then we will support. So before I close this very brief introduction, and I'm not reading what my colleagues have prepared for me, sorry. I just want to yes, exactly. Hello. I'm not reading your speech. No, I just wanted to also flag for you that we have prepared what we call e-learning modules to introduce UNCITRAL's contribution to the Sustainable Development Goals, because sometimes, people ask us, what do you really do when it comes to the Sustainable Development Goals, and to introduce the way we work. So these are 3 modules of distance learning that you can take and that you can please disseminate when people want to know what UNCITRAL does and more importantly, how it works. And we have 3 more modules coming. We have one on mediation, one on arbitration, and one on public-private procurement. The public-private partnership one is still in the works. So these modules are basically the explanation of our text, what the text contains, and how it can be applied, and how it can be. Because for those of you who may not be familiar with what we do, we have, of course, we produce international treaties, like, for example, the New York Convention that predates us, but also the Singapore Convention on Mediation, or the CISG on the international sale of goods. But we also produce model legislation. So it's sort of a ready to put in the oven text that has been negotiated with a view of being totally harmonized and making sure that when you apply it, when you incorporate it into your legal system, it will be the same as in other legal systems, and that it will be completely compatible, and that the judiciary of one country will be able to speak with or to understand what the judiciary of another country has been doing applying these texts. And this works, of course, very well in the area of insolvency, which is one of our strong pillars of work, where the entire regime for cross-border insolvency and including specifically now for MSMEs has been developed and is being used in over 100 countries. So that's really very much what I wanted to do, is give you a little flavor of these UNCITRAL days for Africa, telling you that we are already very happy about the traction they got in many countries and universities, but we don't consider that to be an achievement and full stop. We wanted to grow and become as active and interesting and numerous activities as, for example, in Latin America, where we have, this year we will have over 40 of these events in 16 jurisdictions. So that for us is really meaningful. It really shows how there is interest in what we do. So that's pretty much what I wanted to do and to say about the UNCITRAL days. And now I'd like to turn briefly to the investor state dispute settlement reform. We've spoken about it a lot yesterday. And let me tell you also that I'm really delighted by this opportunity to hear, to listen, and to then think about all the thoughts that you have put into your papers. I'm looking forward to today's papers, because we rely very much in the Secretariat when we prepare the working documents for the working group to work on. We rely very much on academic research. We rely very much on ideas, papers that are prepared, that are presented, that are floating. For instance, when I was telling Martin yesterday that we want to hear more from him on damages, that's not a joke. That is really that is really something we expect, and we're very keen on. Anna had been contributing to the work we are presenting to the Commission this year on mediation. Marc and August, of course, have worked on the Multilateral Investment Court with statutes already out there. So all of this then feeds into the work we do. We are not experts in each one of these different areas, and you will see there are many for reform. But what we know, our value added, is how to spin it in a way that it can then be worked on by 100 or 120, as we had sometimes, countries and delegations in the room that work on one single paper. So very briefly, to introduce the work we are doing. We got a mandate in 2017, so it may seem a long time ago, but it was the end of 2017, and we were starting from scratch pretty much. And the Commission gave the working group 3 a broad mandate, and I insist on this broad mandate. Means that there is nothing in the mandate that says you can do this, you cannot do that, and you shouldn't be looking into this or that aspect. To the contrary, what the Commission said was, first start by looking at what doesn't work, look at the problems, look at the concerns. Don't shy away from looking at perceptions of problems. The idea is not that we have a long debate about is that true or not, but rather that if it's perceived not to work properly, then something has to be done about it. And we also, as you see, there's no limitation as to the reform of that is going to come out. There is no clear direction at that time. And there's lots of flexibility for the working group. There's also no deadline. Sometimes we have mandates which have deadlines. In this case, it's the working group that worked on its own work plan and set its own deadline. And it is about investor-state dispute settlement. And we've heard that times and again yesterday. We're not looking into reforming what is meant by fair and equitable treatment or what is meant by indirect expropriation or how does MFN work. We are looking into the procedural aspects, but procedure is very close to substance. And so we are not disconnecting and disregarding what the issues are, for example, in terms of treaty interpretation. You will see that there is an important part of the coming work that will be about treaty interpretation and about the mechanisms that states, parties to these conventions, but also arbitral tribunal can avail themselves of with regards to interpreting these treaties. We have a number of principles, though, that the Commission asks us to follow. And the first one, and that's an important one in the UNCITRAL context, is that the Commission said that it should be government-led. Government-led means that generally you have experts in UNCITRAL, which are subject matter experts, that are, of course, deputed by their governments to sit in the UNCITRAL working groups. Here, what the Commission said is we want the governments to be sitting in the room, and we want them to have sufficiently high level to provide high level input, but also to make decisions. We work on a consensus base. You probably all know that the beginnings of Working Group 3 did not begin on under the best of auspices, because it was the only time that UNCITRAL had to vote for a chair, but it's still works on a consensus basis. And of course, definition of consensus is the most elastic or fluctuating definition, depending on how you want to move things along. But nevertheless, so far it has really been on the basis of getting as many people on board as possible. It is fully transparent. You can see and hear and listen to absolutely everything that the working group is doing. You go to our website, you find absolutely everything, including the audios. And we are also inviting, and that is a special call to academia, we are also inviting for expertise from all stakeholders, meaning that we are not only listening to the governments, but we have a number of accredited IGOs, international organizations, but also NGOs. And these NGOs range from the International Union of the Notaries or of the In-House Counsel Association to the Client Earth, for example, or a number of more sustainable development centered NGOs. So they're all in the room, which, as Colin said yesterday, makes for many people. But so far we've managed. I also have to say that it didn't come to UNCITRAL completely by chance, because UNCITRAL had already worked in the past on the UNCITRAL transparency standards, and particularly the Mauritius Convention, which has a mechanism that I will tell you later is particularly topical for the delivery instrument of the entire reform package. Because we are looking at, we start from the premises that we have 3,000 something bilateral investment treaties, and that just as the OECD has revised or changed these 2,500 double tax treaties that had to be revised in one go under one instrument, we are also aiming at completely revamping the dispute settlement provisions of 3,000 treaties in one go with one convention. And I'll go back to that at a later stage. We have identified, after the third phase in which we are now, we had first phase where the working group looked at the concerns. Then the concerns were sort of crystallized into bigger clusters. One was, of course, the usual concern of it's too long and it costs too much. The other is a concern about the legitimacy of the system. And there were a number of sub-concerns, not enough diversity, always the same arbitrators hearing the cases, double hatting. I mean, there are a number of these concerns that form part of the legitimacy system and the concerns. And then the third one was the concern about consistency and the fact that we have discussed it yesterday. There were some diverging views, and you can imagine that there were also diverging views in the room when it came to identifying inconsistency in arbitral awards as a major issue. But it was eventually decided that consistency would be a focus of the reform, and particularly when these inconsistencies are not justified or justifiable. So as a result, then a number of proposals were made. You heard from Colin yesterday that the European Union very early on tabled its proposal of a multilateral investment court that would have the features that he presented, being a standing body, having judges that are permanent and having two levels, one level of first instance and a level of appeal. And by this, dealing with resolving the three main issues of cost, duration, legitimacy, and consistency. But there are also other proposals that were made. We have worked on the basis of proposals, what we call submissions, received by states. I would encourage you to look into these submissions, because some ideas that were tabled were quite new. Others were well known. We knew that, in order to cure that particular problem, that would be a solution. And what states would say is that we're keen on going that route, but others have been really creative in the proposals they made. And basically, we're working on developing now a number of reform elements. What I should say to that is we are working on these reform elements always with the understanding that ultimately it will be the choice of the states which element of reform they want to choose, adopt, and bring into their treaty system or into their investor-state dispute settlement system. And not all these reform elements are going to be adhered to or adopted by all the states, but nevertheless, it's important that they all participate in the negotiation, the development of these reform elements, because if you don't join one particular reform element now, you may want to join it in 10 years' time, and you don't want to run into the trouble that many countries had with joining, for example, the WTO 15 years after it had been established. So it's really very much with that in mind that countries are participating in the development of each and every single reform element. First chunk of reform is in the prevention part and in the presenting alternatives to the current system. So the current system is very much based on, if there is a problem, the investor has the right to go to arbitration, and that is the avenue. There are, of course, and I would like to remind those who spoke about that yesterday, that all treaties provide for a period of time during which the parties are going to try and reach an amicable settlement, but they are very silent, or at least Anna has done the research, at least 90% of them are very silent about alternatives to arbitration and other routes that investors can follow. And honestly, when you're a government official and you have a treaty that says either you settle amicably or arbitration, you're not going to persuade your minister that why don't we go for mediation? Mediation on what grounds? Does the treaty say that you can do it? No, so forget it. And so what this pillar of reform is really about is bringing in conducive language to make the possibility to go to mediation available at the outset, and to propose an accompanying guide for parties wanting to embark on mediation. And this is what the Commission will be looking at, because the text is ready. The Commission will be looking at in July of 2023. We will have a set of provisions on mediation, which will then be, by the mechanism of the Mauritius Convention, to simplify, be incorporated in all the existing treaties and in all the future treaties, which means that mediation will become a feature in all these treaties, as opposed to being a feature only in 90%, in 10%, and even there, not in a very clear and conducive manner. And second, we will produce for the Commission's adoption guiding a note for parties in an investor-state mediation. The working group has decided not to develop specific investor-state mediation rules. Why? Because there are already some existing rules, and we don't have much time and much resources to waste in duplicating the work of others. ICSID has just issued a very complete set of investor-state mediation rules. The IBA had produced a set of investor-state mediation rules, and we in UNCITRAL are convinced that our UNCITRAL mediation rules are generic enough to be used for mediation purposes. So we're not going to have now a specific set of mediation rules. So these are the two elements of encouraging and making mediation available in the context of investor state, which it is not so far. It is theoretically, but it's not in practice. So that will be delivery element number 2 that will come to the Commission in July 2023. Other element of dispute prevention, the working group is working currently on a mechanism to exchange good practices in dispute prevention, because there's no one size fits all. But we know from experience now over the years that there are a number of things that states can do to prevent disputes, either from arising or from escalating into a full-fledged arbitration. And this is what the dispute prevention mechanism under this reform will look like. It will both provide some model legislation, because that's something we know how to do. So we will have a model law type of elements that the state can include into its institutional setup. But we will also have this exchange of best practices, because there are lots of things out there that states are doing that work well. Let me just take the example of the ombudsman that Korea has in place to deal with investor problems, and the ombudsman and his investment doctors, as they call it. You have systems that are in place in Peru, in Colombia, that deal really with dispute prevention, catching it at an early stage. And we will be developing this jointly with the World Bank, because the World Bank has been working on dispute prevention and what they call investment retention, in order to avoid that what we all bend backwards to do, which is attract investors into your economy, then results in the investor being aggrieved and leaving. And then the result is that you're a net loser, because you have a dispute and the investment has most likely left your economy. So that's one chunk, that's one reform element. Second reform element on which we're working, and I'm going a little bit to the right, is a code of conduct. This is I had never thought that it would be such a revolution or that it would be taken as so contentious. It seemed to me to be very, very a no-brainer that, you know, we all operate in all our professions with codes of ethics or codes of conduct. And why would arbitrators, when they are providing a service to parties or to under a treaty, why would they not be subjected to a code of conduct? But it has not been that easy. And also, I should say, it's the first concrete text that the working group has produced. And everybody is testing its ability to negotiate, to make changes, etc., with a view to when it comes to negotiating the Multilateral Investment Court, then Colin, you can be sure that they will be ready to fight, because they fought on for double hatting, so they will fight for the Multilateral Investment Court. So this code of conduct we developed jointly with ICSID, and it will be ready for adoption, fingers crossed, if the double hatting issue is resolved for the Commission in 2023. So 3 elements of reform are coming already to the Commission. Then we worked on 3 related topics, which are addressing the selection and appointment of arbitrators, and by doing that also starting to look into the appointment of judges for a permanent mechanism. And we have developed 2 additional papers, one on an appellate mechanism, which is going to be discussed at the next session of the working group, and which is really now at the stage of text to be adopted, and a multilateral permanent investment court, for which we have already elements, but where we still have to work on all the setting up part. Then we have the establishment of a multilateral advisory center, and thank you very much to the Mandela Institute for having held last week a webinar on this proposal that the working group has put out very early on. It's not a new idea, but it's an idea that has a lot of traction. And we have also here already prepared text on what this advisory center could and would do. We have prepared text on who would be the beneficiaries. We have done a financing analysis or budget analysis, and the working group is going to look into that in the months of September. It's on the work plan for the session in fall of this year. Then we have also a number of procedural reforms. And here it's more bits and pieces that are part of the procedure itself that need to be addressed either because they weren't addressed earlier or before in existing treaties, or because they were found to be not functioning properly. And so you have, for example, and there you have to look very closely at the reform or the amendments that ICSID has introduced into its rules. So ICSID hasn't reformed its convention or the system per se, but it has revised thoroughly or amended thoroughly the ICSID arbitration rules in order to introduce new features. And these features, of course, have to also be mirrored in the treaty reform that the UNCITRAL reform exercise will produce. There you will have provisions on early dismissal. We have a provision already ready, will be discussed. Security for costs, allocation of costs. You've heard the discussion about, you know, what happens when you have a claimant who is going bust and who has benefited from third-party funding to bring his or her claim, and who then loses the case. How does the state recover the costs incurred when the state was found to be not in breach of the treaty? Counterclaims, we discussed it yesterday, but we're only talking about counterclaims brought by the state under the same treaty. We're not talking here about the state having a mechanism to bring claims against investors sua sponte. We have provisions on third-party funding that, as you can imagine, have given rise to heated debate between those jurisdictions that know and use and support third-party funding, and those who are extremely opposed to having this third party having a stake in the dispute. We have now, and I told you that yesterday, thanks to a very strong and compelling call by African countries, work on damages and compensation. We will have a reform element on treaty interpretation. We will look at avoidance of double proceedings, where you have under one treaty and under another treaty, and then possibly also under a contract. So you have a state having to fight not one, but 4 or 5 disputes resulting from the same measure against sometimes the same investor, but vertically different layers, and also horizontally through different instruments. And we're also looking into reflective loss, which is exactly, which arises exactly from this multi-layers of investors. The investor can be the investment vehicle in the country itself, but it can also be the shareholders having invested in this vehicle, or the shareholder of the holding company. So all of this results then in the possible granting of reflective or taking into account of reflecting loss. And other cross-cutting issues, you'll be happy to hear that, again, African countries have very strongly insisted that we look into exhaustion. I hope they will not continue to call it exhaustion, but recourse to local remedies, and a number of other so-called cross-cutting issues. And now the important element is, how is all of this going to be delivered? And this is what we have started working on with a group of academics, of public or treaty law experts, who have helped us go through the different practices, what is out there in, say, law of the sea, or in human rights, or in double tax treaties, and have started looking at these different mechanisms that exist in treaty law, how they could apply, given the terms of reference of the working group, that it has to be flexible, and flexible, and that states have to be able to choose, pick, take this, don't take that, and that we still want to have a reform convention which hosts all the reform elements. Even if not everybody adheres to everything, there has to be one single instrument that delivers on this reform of investor-state dispute settlement. Otherwise, the accusation of piecemeal and the further fragmentation would really be accurate, that what the only result is that you're adding a piece here and a piece there. That doesn't make sense, not after 10 years of work. So I have clicked on each one of them. Oh my God, it's fancy. So I did it. So what will the system look like? And I continue to use my little house in the prairie, because I think that it illustrates. It's not going to look exactly like that, don't worry. It will be very different, but it's important to see that the idea is to have a coherent system, and to have something which holds under the same roof and not bits and pieces here and there. So on the two sides of the little house, you will see the stronger support to the parties through dispute prevention and an advisory center for developing countries. On the left, you will see the strengthening of alternative dispute resolution that our colleague was talking about yesterday, how to strengthen ADR and investor-state mediation. And you will see that the multilateral reform that is envisaged doesn't reduce the options to investors. It increases the doors through which investors can enter the investor-state dispute settlement mechanism, but it focuses the entry doors for on what the states really want. So you have states, and we've talked about that yesterday, like Brazil, for example, that continues to favor state-to-state procedures, and they will continue to have state-to-state procedures to bring cases against each other in that particular case on behalf of the aggrieved investor. We will continue to have investment arbitration, be it under ICSID or UNCITRAL rules, because a number of states insist that they want to have this this opportunity of choosing their arbitrators, and that they still believe that arbitration is a good system. We will have a first instance door which will allow investors to sue the European countries and the European Union and all those countries with which the European Union has concluded agreements, for example, with Vietnam, with Singapore, with Mexico, with Canada. Investors claiming under these treaties will enter through that door. And the domestic courts, for those states who wish to make, to continue to reinforce or to continue to use domestic courts to enter this, to allow investors to bring cases, this door will also be wide open. Now, what is going to change the whole system? If you look at these doors, apart from the door in the middle, the first instance court that the EU wants to set up, we have all the other ones are already there. What is going to change is the second level. So there's going to be an appeal system that will apply for state to states. As Colin was mentioning yesterday, the European Union and a number of states insist that the appeal system be available also for state to state disputes. The appellate mechanism will be available for investment arbitration, and that is going to be a very important change. Why? Because we all know that arbitration or arbitral awards are supposedly final and binding, and that they are not subject to appeal. So we will have to revolutionize and make amendments to the current system, probably not through amending the ICSID convention, that would be too complicated, but through having a subsequent treaty that will change, for those who adhere to it, the ICSID mechanism and will allow for an appeal. There will be a second instance for the investment court. And as I mentioned here, there will have to be an arrangement with the ICSID convention. And what you see in the roof, and I just want to highlight that, I was thinking about that yesterday when I was hearing you, is that the treaty interpretation tools and the possible future amendment of substantive standards, be it through the ILC. I'm sure our friend August will be delighted to start working on clarifying fair and equitable treatment in the International Law Commission. No, I'm so surprised. Or other area or other fora where this could be usefully done. Why? Because at the heart of the problems with this entire construct is that the states have lost the control over their treaties, and what they want is to regain it and to have an active role in the way they are interpreted and applied. So here is the floor plan of this little house, and here you will see the different procedural elements, and you will see that they fit quite nicely in the first floor. So all of these reform elements are in fact going to be delivered through the multilateral treaty and will apply to the first instance, to arbitration, to state, to first instance, to domestic courts, and will of course apply to the appeal level. And we have here third-party funding, security for costs, that the mechanism will have to deal with 3,000 existing treaties and will have to cater for a future system for investment disputes, because the idea, and I think you've heard the subliminal message of the working group. They don't want to destroy the system as it is. They want to modify it thoroughly, but the idea is not to say that investors should no longer have any right to bring disputes against the states that host their investment, but rather that it has to be done, it has to continue, but under other rules and premises. And how does that fit together? The reform will be delivered through one framework convention. That's the red part in the middle. Whether this framework convention will or will not have minimum clauses that everybody agrees to is yet to be defined and decided. For example, the working group could decide that all the procedural measures or the procedural reform elements could be a minimum basis that everybody adheres through when adhering to the framework convention on reform. Or they could say that the framework is only a framework and that the procedural rules reform will become one of the protocols that will be added to this framework convention, and that by adhering to the framework convention, you just become a member to the delivery mechanism and to the party, the framework or the convention parties mechanism for continuing negotiations. If, for example, someday this convention would become the host of reform of substantive provisions. Who knows? You know, there may be so much appetite after spending 10 years on procedure that they will all say, oh yes, we love each other so much, we want to continue working together towards reforming substance. So the different elements that you see could be, for example, the court, the appellate mechanism, the advisory center, the procedural rules, the mediation provisions. So all of this will fit into the framework convention, but allowing each state to choose which part of the framework convention they will adhere to. Let's take the example, which is the most obvious, of the advisory center. Canada, the United States, and the European Union have no reason to rely on the advisory center to help them represent them or assist them in the defense of cases. Nevertheless, they may be interested in participating. It has to be totally open to their decision that who wants to become a member of the advisory center. But the advisory center is going to be part of the package of reform that will be delivered by the Working Group 3 and the UNCITRAL Commission and the United Nations General Assembly, because this is how our texts are adopted. So that's pretty much what I wanted to share with you. Maybe just one more slide, because I know they usually put it there. Yes. So what is on the table for the next sessions? In January, we will be discussing code of conduct and commentary, hopefully putting it to bed. And then we will discuss the appellate mechanism. In March, the session which is taking place in New York will discuss the provisions on mediation and the guidelines on investment mediation, because whatever we are bringing to the Commission has to be finalized by the working group. So it's the time when we will have a second reading of the provisions. And in July, we will have the Commission in Vienna, where we will produce and hope to have adopted the code of conduct, provisions on mediation and guidelines on investment mediation. And I wanted to insist on the fact that how do we actually ensure, or how do we try to ensure that we have broad participation, including from countries that are not very active in these negotiations on investment or in whatever fora. We have a fund that is contributed to by the European Union and the Swiss Development Agency, and we can support travel for government representatives. We do that when we get a request from the permanent mission. So it's not you give me a call and say, Anna, can I have a ticket to come to Vienna next time? I would love to say yes, but I can't. And so we then get back to you and organize it. So this is really what I wanted to share with you, and thank you very much for having listened, and call very strongly on all of you to contribute with your thoughts with your academic work, with your interest, and with your support to the work of Working Group 3. There's still a lot on the plate, and we will need all the help we can get. Thank you very much.
We are a bit tight on time
Yes.
right now, so we might have to go straight to the first panel just to. And if there, perhaps if there's any bullet-like questions, just like 1 or 2 minutes. Are there any one bullet?
Shoot your bullet.
My question was on having presented the full idea of the Multilateral Convention, working with this kind of thing, the implementation of it and the distribution of all the existing factors, the big system, the big system. That convention, we really need to example existing circumstances. For example, we have convention that do not physically approach the definition practice that now adopted. Does the working group want to have a convention amending most of the convention or a model law which still to say?
It's going to be through a convention. In order to amend a treaty, you have to do it through another treaty.
Yes.
But it's going to be a treaty that either adds to, like the Mauritius Convention does. What the Mauritius Convention does is add transparency provisions to whatever existing treaties countries have put into the basket of the Mauritius Convention. So it's the same mechanism. You're going to add to existing treaties the whole host of procedural provisions and new structures and systems, etc. All of this will be added to existing treaties. However, in order to do that, you will not only add to, but you will also amend. And that is where it becomes more complicated, because the amendment will, of course, have effects also on other countries that will not accept this amendment, would not embark on this amendment. For example, it's the most clear one, the ICSID Convention. So what we're working on currently is a mechanism whereby states that are adhering to the Framework Convention will also agree that amongst themselves, inter se, as we say, the provisions of the ICSID Convention will be amended by introducing an appeal. So that is the way it's going to work. It will deliver on adding to, which is easy, and in amending existing treaties by saying, oh, what we had in the treaty is no longer valid. It is replaced by this feature.
That's a small follow-up.
Okay. So maybe because we are really running about half an hour behind time, so we better perhaps at lunch. Can I ask you?
Sure. Let's have a bilateral at lunch.
Yeah. Oh. Yeah, maybe.
Okay. Something that just
Yeah.
A comment before they start. Email address uncontrol@un.org, so you can propose your ideas for a potential Uncontrol Day in Africa. And the other thing that should make everybody really excited is whatever the outcome is going to be, it's going to be really complex, which is important for us as jurists, because if it was really easy, no one would pay us to talk about it. So to encourage all the governments to make it as complex as possible, and then we can keep justifying our position. Just let them do their piece, and you can watch and say, all right, you can pay us later and see what the work this mess out. Yeah. I mean, yes. All right, we've
Fine with
I'm
this
going
one.
to keep time, okay? So
yeah. So okay. Great. We are beginning the third panel, and we're starting off with a person with an excellent first name, and I welcome. Well, actually, two excellent first names, I should say. Rimdolmsom, Jonathan Kabre from Jonathan Klein. So please go ahead. The focus is on you for the presentation.
Thank you, Jonathan, for introducing Jonathan. And yes, I would like also to thank the organizer for having me today and to thank all the speakers, because I think we'll all agree that so far we have had excellent presentations. And I'll try also to bring a kind of community perspective on the discussion about how this idea of the MIC can be beneficial to Sub-Saharan Africa. I was happy that the focus was on Sub-Saharan Africa and not on Sub-Saharan African states, which means we can look at other actors still in this region. And I will try to look at how this court can be beneficial to local communities in Sub-Saharan Africa. Why? Because so far in Africa, many investment activities are taking place on territories occupied by communities. But the problem is that those communities are not often associated with the settlement of investment disputes. And I will try to look at what are the specific features of this court that can be relevant for those communities. And I will look at three interrelated questions: the why, the how, and the which. The why is why it is important to talk about inclusion of communities in this discussion. And so far, how have they participated to see the current state of practice? And finally, which of the features can benefit those communities? For the why, to make a long story short, I will say it's because of the lack of adequate representations of the communities in ISDS. And this is not something I'm coming with. It's a criticism, and it's something that was acknowledged by many actors in the settlement of investment dispute. Here I put, for example, a statement by the Ecuadorian government in a case against between Chevron and the Republic of Ecuador, in which the state said that it had no power to represent its own communities. Can you imagine? This from one state, at least it was a tactical move, if I might use that word, but it tells a bit about the representation of those communities. We have also arbitral tribunals. If we look at the border timber against Zimbabwe, the tribunal would criticize to some extent the Zimbabwean government because that government did not include in the public interest defense the obligation that he had vis-a-vis its own local communities. And even the communities, when they wanted to submit amicus curiae submission, will underline the fact that the litigant party cannot speak with expertise or authority to write issues that are directly affecting them. So in a nutshell, those communities are not always well represented. But so far, how have they participated in ISDS? The main procedural channel they've used is through amicus curiae submission, which was made possible through the revision of exit arbitration rule in 2006. And I put here the text of 2006. It was replaced recently by the 2022 exit arbitration rule 67. I think it came into force in July, and I don't think it has been applied in a case involving an African country. This is why I'm still relying on the 2006 arbitration rule. If we look, I put some part in bold. For example, the first sentence, the tribunal may allow, which means it's a possibility. It's not a right for those communities. If we look at the 2022 arbitration rule, it's about permission, which means it may be a favor that is being done to those communities. And after consulting both parties, which means the parties have a right to be consulted, but the rule is not clear as to whether they can oppose. In general, this rule has been understood as not giving those parties the right to oppose because the tribunal has the power to allow. But in practice, in some cases, the tribunal will say, given the opposition maybe of the investor, we cannot allow this community to participate. And the third remark is that it is a written submission, which means they cannot participate in other stages of the proceedings. And here, the last part I put in bold is what I think it's a tension, in the inherent tension in the rule, because the non-disputing party is expected to bring a perspective that is different from that of the disputing party, while sometimes they don't even have access to the materials of the case. How can you bring something different when you don't even know what is being talking about? And so far, amicus curiae submission has been requested in 5 cases involving African local communities. I put the 5. And in the AFC, the last one, the decision is not public, so I cannot, I tried to look, but I didn't find it. But in the 4 other cases, at the exit level, you can see that this was granted in 2 cases and refused in 2 other cases. And as I was saying in the introduction, the tribunal in the border timbers against Zimbabwe refused. And one of the reasons why the tribunal refused such participation is because even the state did not include the right of its own communities. So which means if your own state do not think you can participate, why should we as the tribunal maybe allow you to participate? And in general, it has limited impact on the outcome, even in the 2 other cases where it was granted. For example, in Be-Water against Tanzania, it had no impact on the outcomes. In the Piero Foresti against South Africa, the case was unfortunately discontinued, which means we didn't have this possibility for the community to participate. This is the current state of Africa. And which of the features of the MIC can benefit the African local communities? I think that this idea of appointing permanent members is something that can benefit those communities. Why? Because we are moving from what I call an export approach. I borrowed that word from the submission of the European Union to an ex-ante approach. The exports, because in the current system, arbitrators are appointed once the dispute has arisen. by litigant party, which means sometimes it's a strategic appointment. You would maybe look for someone who can defend your interests in the limit of the impartiality and the independence. But with the proposal of the MIC, we'll have arbitrators appointed by state before any dispute. And as Colin said yesterday, with background in public international law. Why this background in public international law is important? It's because in some cases, state and communities raised public international law issues. And for example, in Bernard von Pezold against Zimbabwe, there was this issue of margin of appreciation. And the tribunal will say, this is an imported concept from the human rights field. So we cannot look at it. This can sound a bit strange because even if the margin of appreciation is something we know in the field of human rights, even in the concept of investment law, we have also the power to regulate, which allows for a certain discretion. But even the recent case, the Eco Oro against Colombia, there was the debate around the exception in the environmental interests. And this was discarded by two arbitrators, the majority. And another element in this regard is when it comes to the interpretation of investment agreement, because some of the recent investment agreements signed by African countries incorporate provision protecting the right of local communities, which means now the problem will be at the level of the interpretation. And with permanent member, I think this can promote a interpretation in the favor. We'll also have an appeal mechanism, which means an opportunity to correct some decision that might not be good. A second feature is this idea of establishing an advisory center on investment law. I know that at the beginning of the discussion at the UNCITRAL level, when they were talking about the potential beneficiaries, they were including other actors, investors, small and medium enterprises, and also in some report, I saw local communities. By the most recent report, unfortunately, did not include those actors. And I think that such a center can be beneficial to those communities because even participating as amicus curiae requires a certain expertise that right now they do not have. And this is important because some actors and some participants in those reforms are now also advocating for the right to initiate proceedings in favor of local communities. If we look at the submission from the government of South Africa, or if we look even at the report by the UNCITRAL Working Group 3, which says that had a matter of legitimacy of the system, it will be important that affected communities and individuals as well as public interest organizations be able to participate in ISDS beyond making submissions at third party. After making submission as third party, I think it's the right to initiate. So which means that now the question will be, how can they be assisted? Because if African states, with all they have, are still complaining about the fact that they don't have the expertise to participate in those proceedings, what about local communities, which so far have been assisted by NGOs, sometimes on a pro bono basis and without any guarantee? Last but not least, and I will conclude my presentation here, I talked about, so far they have participated through submitting amicus curiae submission files. But even when it comes to amicus curiae submission, it's not, they don't have a right to participate in this regard. So, and if we look at also the report here, this is the submission of the South African government, which says that for there to be a meaningful public participation, there must be clear textual rules setting out the ability of the public to participate. And I think here, there are two options that I am recommending. First is maybe to grant automatically this participation to communities when the dispute raises public interest issues. This is one. And the second is maybe to allow them to participate in other stages of the proceedings. I think so far, I checked some agreements signed by African countries, and it's only the United States of America, Rwanda bilateral investment treaty that allows for such a possibility. Thank you for your attention, and I look forward to your questions.
Thank you, Jonathan. We'll have the questions a little bit later, and we'll pass now to Christopher. If you could begin your presentation at the moment. Christopher, could you just give us a couple of sentences about yourself before you start? I'm sorry. I should have that bio about you, but I don't right now. So.
also even more connecting it to, well, the Sub-Saharan Africa. So this, I think, is very important, and you should really keep this focus, or even focus more on this when revising the papers now. So there's a ISDS reform, and everything has to be connected to this, and not the reform of substantive law. If you can reform the substantive law, and I'm going to give you probably an example later on, via the reform of ISDS, I think it's fine, and as long as you can connect it to this region of the world, it's also fine. But one thing I never like to read in conference volumes is something that actually does not have anything to do with the conference theme, and nobody would look for such a paper in a conference volume. One thing I was kind of missing in both papers again is kind of a definition. What do you understand when discussing domestic communities, local communities? It's just a very broad notion both of you are using, and unless I've overread it, but you don't really try to get down to the point. So you're discussing the curable case and this and that. So, but that's partly also about individuals, and individuals suing abroad in other jurisdictions, going to the US. What is about local communities? Do local communities have access to court abroad in third countries? And not only individuals. Then are local communities represented abroad, suing in third country jurisdictions by individuals because they don't have a standing? Could also be something I would, well, just read through the text you've presented again. Then furthermore, both of you are pointing fingers onto, well, the non-functioning international investment law, to generalize a little bit. But the problem, first of all, is the one of domestic law, I would say. So I just would try to be a little bit more careful, pointing fingers directly about, towards non-functioning international investment law, when the problem very often is very much homemade, at least from my perspective. Of course, we have deficits in international investment law, no discussion about this. But it's the whole state of the investment that should be responsible, first of all, and this also has to be taken into consideration when now negotiating new approaches. Then next point, what I would call in general an imbalance. 80-20 I've written down. So you're describing the problems, 80% of the paper, and then you're starting with the multilateral investment code. What is supposed to be changed? Where are options? You're just starting, and then you're done with the paper. So I would shorten the first part, or try to even get parts of the current problem under the topic what reform options are there. And then you just, both of you, just taking a little look at well, what has been presented so far at UNCITRAL. But again, the reform, it's an open process. You can come up with more solutions. The only thing is that it has to fit under the topic of ISDS reform. So, I mean, you have to be innovative. You can come up with, well, new ideas, new proposals. And this is come come up with better solutions. Don't be afraid of proposing something. This is what we are supposed to do. Just throw in new ideas, and if they are torn apart afterwards, fine. Doesn't cost money. It doesn't cost anything. Just you have to give good reasons. You have to make really your point. But not just repeat what others have written and then stop, like both of you take this 3-point approach: introduction, discovering the problems, then turning your attention towards the international investment or multilateral investment court. And well, one could use this, one could use that. That's, I would say, there's still more room for improvement if you really extend the last part. Then also in this regard, I don't think these papers are meant to just fill up many pages, but reduce what is not really necessary, what others have already written, and then focus on the reform. Because, well, much of the stuff both of you have given attention to, we also read elsewhere. But the reader really wants to read about the ISDS reform, and under the ISDS reform, then probably take up some parts of what you have written already in the now second part of both of your papers. So it's a little restructuring. Then the first paper, well, I was thinking you make it really clear that your point is that host states are not representing anymore the communities, or not all the time, that they have kind of a self-interest, the host states or the public officials, that well, the state level is not always working in the same direction as the local level would like the state level to work. So this is also the reason from your perspective why international investment law needs to take over. Then the general question is, are you not altogether questioning then the idea of the state, the responsibility of the state, and are you not actually discussing more the idea of global law, global administrative law, global possibilities, but going away from ordinary structures so far? And then again, is this still within the reform ideas of ISDS? Because what I take from that approach is that you're actually going for global court and global court with a similar functions as the European Court of Human Rights, for example. But in this regard, we're missing the substantive law. If you want to go for actually these global approaches, which is far beyond ISDS, well, then it's the question with the global law, global administrative law. Nevertheless, you're also really focusing on the new approaches in substantive law. And this I would really try to put together with your idea of the permanent members, what you're really focusing on, that you say, well, we're permanent members, permanent judges, and if these permanent judges apply a reformed approach of substantive law, and you're giving many examples, this might lead to a reform process. The Investment Advisory Center, I don't think is, well, it's really something new, innovative, but, well, you should consider again taking a closer look at jurisdiction. this could be connected to ISDS procedural reforms, taking a look at jurisdiction. For example, something innovative would be implementing a screening mechanism for ISDS, because then it's only in conformity with host state law, and one could introduce such a mechanism. So this is just an idea, an example of how to look into the future. The second paper, also there, I would discuss this transnational litigation as you do. But again, you're taking it from the perspective of the individual, not from the perspective of local communities. You already mentioned in your presentation the Dutch cases, which I don't find yet in your paper. So it's not only the US jurisdiction, but well, take a look at the UK, what is going on there, take a look at the Netherlands. So I think we are starting new ways there, also with the supply chains responsibilities being discussed all over, and responsibilities under these new acts, also in the European Union. We might come up with more work in this direction. Well, I think my time is over, right?
Do you have another?
Yeah. But also in your part 3 regarding the MIC, be innovative, come up with more ideas. Ad hoc judges representing local communities, whatever, but not just summarizing what has been presented up to now, but something where you think it could help local communities. But again, don't forget, it's changing the system, what you're discussing here. And if you want to change the system, if you take a new approach to the idea of consent in this entire field, by all at once giving access to the MIC to new players, and via that, questioning the idea of consent that we did have so far, then come up with the solutions. Thank you.
Thank you. Okay, that takes me back a little bit to my university days, but also to when I submit articles for publication. It comes back with criticisms, and I think a fair phrase is there's room for improvement. But I think also suggestions, and that's part of the spirit of constructive dialogue that we're going in here. So along those lines, yeah, Martin, stand up, please. Not actually, I think Patrick's been delayed on his way here, so you're our roving mic person. But I'd actually like to see if there are any questions or actually comments from the audience at this point. And I see several hands, so we'll go with at least 3 of those. Martin, if you could, oh, you're good. I think
Thank you very much, Jonathan and Christopher, for this very brilliant presentation. My question goes to the both of you, but I will start first with Jonathan. So in your recommendations, you actually made 2 recommendations at the end of your slide. One of them is granting automatically the right to submit amicus briefs when there is a public interest concern engaged, if I'm correct. So my question is, who determines that there is a public interest issue in a case? And should it be the parties, or is it the exclusive determination of the tribunal? And if that is the case, should there even be a test that should be applied in determining whether an issue is of public interest concern? My second question goes to Christopher, and it's surrounding the issue of consent. I am kind of curious because under the current regime, we do know that an investor consents to arbitration whenever it submits its dispute. And then the state's consent, we can derive it from the treaty or whatever is the basis of the claim itself. What will be the basis of consent for the investor when local communities are able to bring a case? Because I assume that local communities also, by implication, have consented when they submit, but what about the investor? So I'm kind of curious about that here. Thank you.
Thank you. My question is directed to both speakers. You didn't touch on this, but maybe you might have thought about it, is that even if local communities, third parties have a right to come forward and bring their case forward, how would this be, number one, cheaper for them? And what would be the education for them to know that they actually have this right? Because if you take, for example, the Von Pesselt case with Zimbabwe that you mentioned, the chief in Nyinevi did not even know about the treaty. So how do you then conscientize perhaps the local communities to know that they actually have this right? Because the government of Zimbabwe in that case as well did not even bother to inform them on that. It was the work of the ECCH HR which ended up allowing them to come forward.
Thank you. Just a quick comment. Let me play the advocate of the devil in this debate. For both presentations, they assume legitimacy of the local communities to participate in the cases. But I think it would be good to have a reflection on the grounds of this legitimacy, because I'm not sure it can be assumed. And also, I relate this to the debate about amicus briefs and WTO dispute settlement. And there were discussions whether the amicus briefs by NGOs, or for example, would have to be endorsed by the state or whether they could come independently. And one issue in the debate was that according to international law, the state is a unit and is supposed to represent the whole people. And if you allow internal communities to the state to intervene on their own motion, including eventually against the point of view of the state, then you question also the legitimacy of the state. So this was a debate. I'm not taking side here. I think simply that it has to be tackled somehow, whether some self-instituted communities saying, I am a local community, I'm entitled to have a point of view which might deviate from the one of the state, which according to international law is supposed to be representing the whole people. So there is a whole balance to be considered here. Once again, I'm not taking position. I simply think that for the argument to be stronger, these issues should be tackled upfront and not based on assumptions. And so thank you very much.
Hi, I really enjoyed your, just as a comment, excellent presentations. As you guys, both of you were talking, the thing that came to my mind was that certain countries have very stringent CSR requirements in their environmental legislation or other things. Would certain countries then be able to just mention that and therefore be able to, allow for the panel to disregard then the voices of, the local communities? Because, well, we have these processes in place and they've been heard. An investor could raise the same argument. So in one instances, are you also looking at sort of perhaps the idea of, model legislation that sort of goes, if you have these, then there isn't the space for these communities to bring it up further. Yeah, just a comment.
Thank you, John. I mean, I think just to reiterate what Marc said just now about the focus of the paper and the structure, And I suppose that's what I have also seen since yesterday. That's what I emphasized on. So the issues around consistency, these problems, they are old news. We know them. You can summarize them in the introduction, but the body of your paper should really be focusing on your reform proposals. So I think that's really what you should be taking home from this conference, this workshop.
No need for reports. Okay. I would like to make one general remark. I really regret that we had access only to the papers on which we were commenting. If there is any possibility of putting all the papers on Dropbox, that would be absolutely lovely. And connect maybe in a round mail everybody, so it's easier to talk afterwards. I have two questions and one remark. One is, and I remember on the Bywater Gulf case, so the amicus curiae which was submitted was by the Canadians, right? And they had incredible, they were really at pains, and that's their big problem, is how they get access to information. So I wonder whether you would need to make a good amicus curiae brief, because otherwise, the tribunal would just disregard. So are there any mechanisms you can think about that would enable people to submit an amicus curiae? Because that's part of the access to justice. The other issue is, that's a remark, I do not have any problem with the consent of the investor, because if that's built in the institution and you as an investor consent to the package, if you go to arbitration. So I have no issue whatsoever with consent on that matter. And then I felt you're somehow shy. I know, I'm going to talk later about it, but you're somehow shy in getting the interests of those people affected into the system, just with amicus curiae. What we are discussing now is liability. So I feel you're really shy on all that. We will discuss that later, but congrats on that step. But it's really a small part of the puzzle.
I think mine is just to give an idea, maybe when we are restructuring the papers, is on the issue of the local communities. Maybe you both may consider the issue of maybe the solution of how these local communities have access to the IMIC. As Prof has rightly said, we are trying to give more solutions, is through the policy level, even if it's like Lafia said, a model law which guides countries to come up with local laws which ensures communities participate through the state, because maybe widening the jurisdiction and allowing local states directly access to the MIC sometimes might be a problem. Maybe that is one solution we may consider: policy and a model law, whether each country should have its own policies to involve the communities, or a model law, which now countries model their policies and everything to involve the community that access the MIC. The last thing is on the issue of multi-party disputes, whereby the states might have a claim against itself, and that claim, the investor might have a claim against the state, and the local community might, through its amicus or being involved in that process, have a different claim to the state, a different claim or a different view rather than the states. What happens when they are conflicting? The local community is screaming this, and the state which is sued is screaming the other thing. The last one would be the issue of third party taking advantage. This we are discussing with Martin in the morning. A third party comes in, a lawyer, a very big law firm, says, because now you have access to MIC, we shall support the litigation or the arbitration process and pump our money. Whatever you get through the MIC, we shall take 60% of it. So the local community end up even not benefiting. So that limitations also, because the local community might not even have the real capability to go to MIC. So they might need another law firm. So all those are issues you may consider. That's all.
Thank you. I think there are also other things that you have to perhaps take a look at. The first one is it relates to the advisory center. I think we have to also see how the center is structured or composed. So to see if it can take into account the interest of local communities. As it stands, the text is not, the representation of the advisory body is just on micro, small, and medium-sized enterprises and investors. So it's like it's business oriented, but the local interests are not taken into account there. So the center is there, but its composition has to be looked at so that the local interest could be taken into account. And then there's a suggestion of having automatic granting of amicus curiae. And I'm just wondering, how do you ensure that the judicial integrity is not compromised by opening the door to everyone to say, just come in? I think the issue has been mentioned that it's a public interest, but we need to determine who determines that that is a public interest issue. And of the other issue relates to the role of domestic laws as it relates to representation of local communities. Are we going to tie representation of local communities to local laws? If your host state laws, they don't allow such kind of representation as was indicated in the Zimbabwean case, is this something that is to be considered at the MIC, that you also have equal representation or you don't have equal representation thereof? There's also the need to define what are local communities, because we do have different definitions there. And now within the MIC itself, what is it that amounts?
That's it. Can I just add a quick comment, but no question? Yeah, what Marc Bungenberg said about one of the important things is you respond to a problem with this reform. So obviously the problem would be domestic courts aren't working as well as they should. That would be the ideal solution, to have all cases go to domestic courts, because this is very exotic. You can probably get past that problem, but once you do and you put your proposal forward, then you need to think about, well, let's be careful what we wish for, because what's going to happen is, I suspect, you'll have a local community bring a case, but let's be serious. The local community was approached by an NGO with a certain ideological persuasion, and they said, we want you to take this case. So there'll be a proportion of the local community that's represented. There's probably another portion of the local community that works at the local gold mine and thinks, you know what, I've got a pretty good job here, so, back off. And then the other thing is the lawyers, of course. Some of the law firms that might get involved in this case, honestly, they have the morals of an alley cat. If you want me to give you some examples, I know I'm being recorded, we can talk about them, but a certain British law firm is basically now banned from doing business in Kenya after they learned about their business model. So, all right, that's it.
Okay, so if the mark of good papers is generating lots of discussion and questions, then, A+. And there's really lots to talk about. Fola and I were exchanging glances. He's worked at the South African Human Rights Commission, and the interplay of communities and lawyers and ideologies is a really important part of all of this. So there's too much for you to actually respond to. I'm going to give you each a good solid 3.5 minutes each. And I know you're going to have to select. Some of those comments and questions were overlapping. So do what you can in 3.5 minutes each, please. Thanks.
Can you hear me? Okay, thank you so much. So first, thank to Marc for his comments. I think there is a lot of things I can take from those comments, actually all of them. And also thank to the colleagues for the questions, the comments. I tried to write all of them. And in the interest of time, I think maybe the first one should be the definition of local communities. I think this, to be honest, I tried to avoid that question because at the beginning, my focus was on indigenous people, which is a more contentious issue, even the African level, if we look at maybe the recent OJ case. in which the government of Kenya was denying the state of indigenous people to its own people, saying that those people, it's true that Ojek people are indigenous people, but those Ojek people are different from the previous Ojek people. So it was becoming something else. So it was a way to avoid that discussion around indigenous people and come with something that is less contentious, but apparently I think this one is more contentious. So in my view, a community is a group of people, families, but who have historical ties with a territory. I think the link to a territory is important, in my view. It's true that this is one of the elements for the definition of indigenous people, but I think this criteria is one of the most important ones. And it helps me maybe to respond to Folabi. When it comes to public interest issues, maybe I should have, for me, if the investment is taking place on a territory occupied by a local community, there should be associated to everything that is linked to that investment, because this is part of the identity. And when it comes to indigenous people, the link to the territory is part of the identity. So maybe I will try to find another word, maybe not public interest, but all the investment that are taking place on the territory. And maybe to respond to Hélène about the legitimacy of even those people, I think the relationship to the land is maybe a good argument in this regard, because this is part of the identity. So, but what I think I would like to think about more carefully is maybe this issue of amicus curiae, because I can use two elements to say, if I want to respond to the question of whether local communities are legitimate, maybe to submit an amicus curiae file, I will say first, because even when we look at the exceed arbitration rules, for example, the rule 37 paragraph 2 talks about a different perspective, which means even in the rules, we acknowledge that other people can bring a perspective that is different from the state. So, and I think this Westphalian assumption according to which the state can represent all the interests of its people now is big. We have a lot of argument against that, because even the fact that investors were given access to investment court and tribunal is a sign that sometimes the home state cannot even adequately defend the interests of its own investors. This is why they have access to it. If not, we could go back to diplomatic protection. So, but I see what you are trying to say. So I think I will try to spend more time in drafting those arguments so that maybe to avoid those confusion. I know there are many other questions. I will be more than happy maybe to have side discussions and maybe in the interest of time to limit myself here. Thank you.
Thank you. So I think there was a question directed to me about awareness creation and whether local communities may even be aware of the court and all that. Yeah, I think, well, NGOs have played a very important role in litigating cases before regional human rights courts. So I think that the same can happen if we have the Multilateral Investment Court having jurisdiction to deal with issues relating to local communities. So I don't think that would be a major problem in my view, necessarily. Then there was a question about whether if, let's say, a company does consultation or there is prior and informed consent, that can be a defense to an action being brought against the company or the investor. I think there can be a separation between the obligation to consult and what happens after the consultation process, because I don't think giving consent to a project necessarily implies that you have waived your rights to later bring any claim if any actual injuries result from that process. So I think those two can be separated. The obligation to
not consulting the local communities can itself be a basis for liability. And I think that's also separate from whether or not the investment has actually caused, let's say, environmental damage or human rights abuses have been occasioned to the people resulting from the investment. So I think we can separate those two. And then there was a question about whether opening the system up would not compromise the integrity of the judicial process. And I think that's why in my presentation, I mentioned, for instance, that there can be some control mechanisms or guardrails so that you can say the action should be in representative capacity so that you don't have multiplicity of suits all over the place, or let's impose a serious or widespread violations test so that you don't have trivial incidents being litigated at the court, etc. So I think those are ways in which we can think about how to ensure that access is granted, but at the same time protect the system from a total upset, right? So I think that's one of the ways we can look at that. I think that, yes, the follow-up question about consent, I think Prosan especially answered that, so I don't need to repeat that point. Thank you.
Okay, thank you very much to both of you. And I'd really encourage the persons who've made comments and questions to engage at lunch, or start up an email conversation. That's really, it's really helpful in events like this to present your work and get an idea of what questions and what comments comes back. It really helps in taking things forward. So even if we can't talk about everything that that we want to because of the time constraint. Okay, so we're going to move on to and thank you very much, Marc. We're going to move to the second part of this panel now, and that actually means we begin with a presentation by Robert Kwame. And if you're, I'm not sure, yes, Mutumbe, I'm sorry. If you can actually step up to the podium, do it. And if you can introduce yourself with a couple of sentences, please, that'll help. Okay. Now, Sitandikele is not scary. Go up. Yeah.
I know the pronunciation is a bit problematic. I'm from Kenya. I'm a lecturer at a university called Egerton University. I also am a partner at a law firm in Nairobi called KMK Africa Law. So that's briefly about me. The title of my paper is Why Multilateral Investment Court Without Equitable Inclusion is an Illusion for Sub-Saharan Africa. The title may sound a bit pessimistic, but it is not all that pessimistic. So this is the outline of my presentation. I will underline the term equitable. So from the title of my paper, why the MIC court without equitable inclusion would be an illusion. So it means that then perhaps we need to understand my use of the term equitable. And with that, I will just draw a comparison between the two terms within the concept of justice. I will also, let me not highlight now, but you can see the outline of my paper. For the sake of time, let me just go to the first item. The understanding of equality means that all parties are being treated the same, while when we understand equity means, from the way I'm using it in this paper, it's that we are treating different parties differently. And just to quote from one philosopher, Aristotle, I know this concept of justice has been a matter of discussion by many philosophers in history, and justice may also connote issues of equity. And here Aristotle was quoted as saying equals should be treated equally and unequals unequally. So I will try to link that to the current process of reforming the ISDS. And it is my argument that we have unequal parties. We do not have all the states coming into the discussion. In the current discussions on the reform of the ISDS. Politically, you will find that some nations are, to use the word powerful, others are, have less political say. And to contextualize it with Sub-Saharan Africa, I would say then that Sub-Saharan Africa would be considered with little political say if you were to look at global affairs. Historically, Sub-Saharan Africa has a disadvantaged history. We all know that most nations were subjected to colonialism. And I will discuss briefly about neocolonialism in this presentation. But as a result of neocolonialism, we find that the African way of doing things, including the African way of dispute resolution, was relegated. It was regarded as inferior, and subsequently Africans have disregarded homegrown solutions, and they prefer more of Western ideas, foreign solutions, including some countries have laws that are more of like a transplant of the laws in another country. I would give the example of Kenya with some, for instance, the Companies Act borrows a lot from the UK Companies Act. That is just an example of how these nations have preferred foreign solutions. And they do not really take much time to think about their circumstances and homegrown solutions. So this is the scenario in which these nations are coming to this discussion on the reform of ISDS. And it is doubtful whether they will be able to really think outside the box. And there is a likelihood that they will follow the bandwagon. They will just follow what is being proposed, or they will be boxed into it in a way based on the power equation. Economically, there is also an imbalance. We have most of the nations in Sub-Saharan Africa having weak economies. Then I would also say that with foreign investors coming to Sub-Saharan Africa, most of them come in at a time when these nations or these states really feel that they need that foreign investment. So there is still an inequality. So with that, that is just to cement the argument that we are dealing with unequal parties, and therefore there is need for an equal treatment, or then equitable inclusion of these states. So going forward, I ask then, are there certain underlying interests in the process of reforming the ISDS? We understand that the MIC is a brainchild of the EU, and I ask, what is in it for EU? I will not answer that question, but I know that in the criticism for the ISDS, we have interests that are being protected. That's why states want to reform the dispute resolution process so that their interests, investment interests, sovereignty interests are taken care of. Now, then on this issue of interests, I argue that the Sub-Saharan Africa has unique interests which are not shared by the developed nations. And that also then is a factor to consider in the process of the reform of the ISDS. So then just question then, to what extent will these ongoing discussions yield a multilaterally acceptable solution that will address these underlying solutions? So if we were to address the underlying solutions that will take care of both the developing states in Sub-Saharan Africa and developed states and the EU and all the parties involved, then we have to come up with, we have to adopt an approach that then I say should be equitable, treating different parties differently. Let me just quickly highlight some of the unique challenges that Sub-Saharan Africa has faced, and I highlight three of them: neocolonialism, corporate state capture, and what I say then is a perception of foreign courts. Quickly, neocolonialism, I have highlighted it as I began. The consequence is that the mindset of most policymakers in Sub-Saharan Africa is inclined to looking to the West for solutions. And there is also the fact that most of those nations in Sub-Saharan Africa took a trajectory economically and politically that was largely informed by what was impacted by colonialism. So then we have an impact of neocolonialism in trying to look at a solution for the ISDS. Then I look at corporate state capture as a challenge that is facing Sub-Saharan Africa. This is mainly because the foreign multinationals that are investing in Sub-Saharan Africa have undue influence because of their size and the need that is there in Sub-Saharan Africa. So we find that there is a likelihood of the regulatory agencies being influenced to act in a manner that will benefit the state, the foreign corporations. For the sake of time, I just move on then to say that then forms the basis of equitable inclusion treatment. Let me then move on to say, looking at the current discussions, what are there efforts that have been made? Do we see evidence of equitable inclusion? Then I would say that if you look at some of the provisions, like the provision for the advisory center, it is a consideration that developing nations are different. That's why they need the assistance of the advisory center. So it means that there is actually an appreciation of this problem, or rather this need for equitable inclusion. Let me just move on because I see my time is up. I highlighted, if you look at the note from the Secretariat on nomination, selection, and appointment of candidates for the proposed MIC, the last part there, in addition to the qualifications and other requirements, appropriate diversity such as geographical, gender, and linguistic diversity, as well as equitable representation of the different legal systems. Just to summarize, there is an appreciation that even in the selection of judges, then there is need to have equitable consideration. although it's not coming out clearly that it is considering developing states as requiring that, but it's just an appreciation that it has considered that. So those are some of the recommendations that I highlight on. I highlight recommendations that would be geared towards achieving this. So I think my time is up. Then I would end there. And thank you.
Thank you, Robert. Yeah, Richard. Richard Mlombe is from University of Malawi. And his title is going to be, should the envisaged multilateral investment court have jurisdiction over human rights and environmental counterclaims? So Richard, do feel free to, if you can give us a sentence about where you're at university. Yeah.
Thank you, and good morning, everyone. I hope you can hear me. Yes, so my name has already been mentioned. I'm Richard Mlambe from Malawi. I'm a lecturer at the Malawi University of Business and Applied Sciences. It's a public university. I'm also a legal practitioner in Malawi. So I think, yeah, basically that's what I can say about myself briefly.
Is that Lilongwe?
It's in Blantyre. Yes, but the capital is Lilongwe. But I'm based in Blantyre. Sure. Thank you so much. So the topic of my paper is, I think one word was misspelled there. Should the envisaged multilateral, the word multilateral was somehow misspelled, to correct that, investment court have jurisdiction over human rights and environmental counterclaims? So just to say something about why I thought this is something worth discussing in the context of the envisaged MIC, it's what motivated me is the fact that, and I think this has already been mentioned by previous speakers, that normally when there are disputes between investors and states, host states, there have been times whereby states have been justifying measures that were challenged by the investors by showing that there was something that compelled them to take those challenged measures in order to correct some problems that were introduced by the investor itself. So, for example, there have been times where states have alleged that, for example, we took these measures which are being challenged now because we thought if we didn't, it means the environment was going to be affected or damaged in a way that maybe could be irreparable. You see, so states have raised those by way of counterclaims to say, okay, if you're accusing me of taking a measure that you think is preventing you from benefiting from your investment, I will also counterclaim by saying, look, you have caused something that I need resources to correct. Where would I get that money to repair the damage that you've caused? So if I'm condemned, you should also be condemned similarly, so that I also get something to correct what. So basically that's the idea. But now, why should this concern the MIC? So the idea is, you see, the reality is that African states, African jurisdictions are the ones that are in this investment relationship. They are predominantly recipients of investments rather than exporting, because the more developed states are the ones that are predominantly exporting. So it's an issue that is a real issue for African states, because they are likely to be the ones to consider counterclaiming in this manner. So that's why I thought I should discuss this. So here I'm just there I'm summarizing to say there are a number of, it can take the counterclaims, the issues that states may want to use to justify the measures that they take may take a number of forms. For example, they may say we're trying to protect the environment. they were saying the state can take measures which may be in a form of maybe taxation policy. We have adopted a new taxation policy and someone thinks I'm being taxed too much, and the state can justify why it has taken that measure. Issues of foreign exchange, competition law, we are prohibiting this conduct because we think it's uncompetitive and it's an unfair trade practice. Someone thinks this conduct is preventing them from enjoying there. So I was just trying to show that you can take a number of forms, but human rights and environmental are just like some of the more salient and indeed frequently raised, but they are not the only ones. By no means they are not the only ones. So yeah, that's what normally happens. But now the challenge is when a state raises a counterclaim against an investor and bases it on, let's say, environmental regression. The state says, I adopted these regulatory measures because I wanted to protect the environment. You will find that jurisdictional challenges do arise also because the investor may respond, and this is common frequently. They will respond to say, no, the issue is about investment here. So what effect has the measure you've adopted? What effect does it have on my enjoyment of my investment? It's not a question of environmental law. No, this is not the correct forum for us to argue those things. And sometimes the tribunals do say, yeah, under this treaty, I think what I should be concerned with are the commercial and business interests at stake here. What effect does the measure that you've taken have on those interests? If you are taking me human rights way, I think that's outside my mandate, and no, you can take those to another forum. And you see, other authors also have indeed identified this as something that distinguishes investor state arbitrations from maybe international commercial arbitration, whereby they are deemed indeed to be one-sided as far as some of these obligations are concerned. And it may be difficult indeed in practice for states to raise counterclaims. I've quoted Kabre, one of the well-known practitioners in international arbitration. In one of his books entitled International Arbitration, he has actually listed this as a feature that makes international investment arbitration unique, it's different from others. Now, having noted this, I'm inspired by this statement that was made by the predecessor of the ICJ, the Permanent Court of International Justice, that it is a principle of international law that breach of an engagement involves an obligation to make reparation in an adequate form. Reparation, therefore, is the indispensable complement of a failure to apply a convention, and there's no necessity for this to be stated in the convention itself. So this is the case concerning the factor that Charles, that's where I'm quoting this from. Yeah. So look, I think this statement, in my view, can also be the basis of saying when there is this relationship between the investor and the host state, it does not need to be expressly stated that when there are certain violations, the following is the list of things which, if one of the parties breaches, then the other one will have a remedy, especially those that are non-contractual in nature, such as violations of the environment and human rights. To me, I think where a state can establish that this particular violation, although it is not stated expressly in this treaty, as long as the state can show and establish that it was committed as the investor was trying to enjoy and exploit the investment, I'm of the view that it should attract the obligation to make reparation, reparation. And so studies have been made to see how often do tribunals refer to and are indeed concerned about human rights and environmental issues. So there are figures here. There was a study that was done for awards rendered in various arbitral awards tribunals between 2010 and 2018. 123 of them were analyzed, and the findings were that those that made reference to 123 of those out of 355 mentioned something like human rights in their words, and yeah, but out of those 123, 37 of them made just a marginal reference to human rights, and therefore this means 86 of those awards made non-incidental, non-marginal mention of or reference to human rights. Those 36 can also be broken down further, and you find that out of those 28 show a positive attitude towards human rights consideration when you're considering investment issues. 9 reflect a negative attitude, showing that no, we don't think these two are related and we should really consider them. And 49 were kind of somewhere in between there. So let me make a disclaimer here. One thing that I think I should have also checked is whether these human rights arguments were expressly pleaded by the parties. I think that's something that I can check later. I need to make that disclaimer. Now, I'm talking about counterclaims. States ability to counterclaim. Now, I think it's not good to claim that there is nothing that has been done. Looking at the ICJ, we can learn something from the jurisprudence of the ICJ, and I think it's good because it is also a permanent court, which means it shares some features with the envisaged Multilateral Investment Court. There is a rule on counterclaims, which have reproduced there. And interpreting this rule, the court has singled out 2 features. Firstly, that if you are raising a counterclaim, it must be of something over which we have jurisdiction. And secondly, it bears a direct connection to the issues that have been brought by the other party against whom you are counterclaiming. I want to propose that in the Multilateral Investment Court, there should be firstly, express provision that the court will have jurisdiction to handle counterclaims. But in terms of now the criteria, I think we can borrow the same from the ICJ. What I would now suggest is the interpretation to be more generous. If it is something that has been counterclaimed within the context of the same investment, and the state can demonstrate that the breach it is alleging against the investor was committed as the investor was exploiting, it means to me there's jurisdiction and direct connection between the two. Not a wholly unconnected claim, like to say you evaded tax one day, so we are counterclaiming for taxes that are due to us, pay us. No, I think that would be very different. But for you to show that as you were doing something on the land we allocated to you, we said, do not do this, which you did. To me, that's something that does not necessitate express provision in the treaty. My time is up, so maybe just by way of conclusion, I think I can just emphasize that I think on the procedural issue of counterclaims, the MIC should expressly be given that mandate, and the interpretation should be generous if it is to benefit the predominantly investment recipients, which are in the Sub-Saharan Africa. Ladies and gentlemen, I thank you so much for your attention.
Thank you. I think without further ado and without introduction, I'm going to pass over to our commentator for these 2 papers. Emmanuel?
Thanks, Jonathan. Okay, so I've read the 2 papers and I'm going to make some comments, and some of my comments will be generic to both papers, and some will be specific to the papers. So let me start with the specific comments. And sometimes I guess I might digress into the general one, and I'll point that out when that happens. I'm going to start with Robert's paper. I thank you very much for the efforts and for the work done. I think that paper conflated a lot of things. So let me check, quickly state kind of by way of summary what I got it from the paper, at least from the written paper. And basically the what I took from the paper is that it's arguing that Sub-Saharan African countries or the region has some unique needs, unique interests. And as a result, they should be given some differential treatments. Now, the paper spent a lot of time talking about trying to mention or trying to construct the argument about why Sub-Saharan Africa has those special interests. I found those to be very superficial. I think most of them were kind of just going into kind of the conspiracy theories and colonialism. I think we need to go beyond that and begin to engage seriously with serious issues. And I have often when I've had this argument with people, I know a lot of African scholars. I think we're kind of going to continue to dwell on some of this kind of conspiracy and the underdevelopment of Africa is due to colonialism. I think we need to move beyond that, and especially in the context of this paper, I thought that a lot of the time and a lot of the space was actually kind of wasted on things that were superficial, not done in detail. It was repetitive. So it's something that I will advise, or I will suggest that you have kind of a look at, and just, if you want to construct a need, definitely. I mean, we know that most of South Africa is developing country, is developing. So, there's some sort of a, let me say, disadvantage or inequality there. That's fine. And you want to then kind of Aristotelian quotes that you gave, that it should be treated unequally, because then that's or differentially, and that is equity. I agree with that, but then it needs to dig into the actual needs. But a lot of the paper kind of was about special needs, special interests, special needs, special interests, and that was mentioned. I counted at least 15, but I didn't tell exactly what these are. All right, so we need to go beyond that. Then the actual kind of equitable inclusion, you listed actually, in fact, when I counted it, it's about, you've listed them to be 9, but actually you jumped 4th. The 4th points, I would say 8. I'm going to kind of summarize them very quickly, maybe for the audience and for you as well. So it talks about reserving positions. Some of those I think might be a bit provocative, or maybe unrealistic or impractical. But there are other aspects that about 2 or 3 that I can take to say this. Okay, they make a real kind of a point there. But coming back to actually what you finished on in the working document, quote, actually, there is actually some difference or thoughts about equity there anyway. All right, so it's not as though it's not being thought about. So you've got to look at it and say, okay, if this is going to be done, what does the kind of the region need, or what is the region going to push? Some of them are, so one of them is about costs and funding and finance. I think they can be developed a bit further, but if I want to kind of summarize it, and it's about 3 or 4 points that deals with it. So basically what you're saying is that the envisaged multilateral investment code is going to be funded by member parties who have signed up to it. And so if you take, for instance, even in the World Bank subscription system or whatever, well, South African countries don't have as much funding, as much money as developed countries. So therefore, when it comes to funding the courts, Sub-Saharan African countries should pay less. All right, I think that makes sense. That makes perfect sense. I would like to think that an international institution of that nature will naturally do that. I don't think they're going to go and say, well, EU funds it by 100 million, each and every African country should pay 100 million. I don't think it's going to, but at least this is something that you can make more explicit in terms of costs. I think another thing relating to costs is, which is one of the points you make, is that when it comes to, it wasn't as explicit as it, but that's what I thought maybe I would suggest, if that's what you want to engage with and look at it. If an African country were to be a defendant or a respondent in the court, or were to initiate, assuming that they can initiate their cases, then the fees they pay to the court should be less than what maybe a developed country may pay. So that's kind of another example of the differential treatment. Then you go into appointment of judges. As I've stated, and if you put it up there, that's already kind of taken into consideration diversity, agenda. I think those are already in there, so they're not unique to Africa. But yeah, you can kind of points to that as well. Now, you dwelt a lot on affirmative action. It's something that can be problematic, but you can hone in on it kind of a bit more, or now step back from that and make a more nuanced suggestion. So that's basically maybe where I will leave my specific comments on your paper. The paper. No, but we also know that when it comes to human rights, jurisdiction by human rights, there are a lot of kind of technical issues. But I will actually say that this probably maybe suggests one of the things that Marc just mentioned, that you can be bold and do something that is innovative. All right. One of the problems when it comes to human rights is that it is, as it is, it's kind of the obligations that are constructed and seen to be obligations of states, which are supposed to be kind of imposed or respected by governments. So that's that's kind of the mainstream constructs. So maybe the innovative part is to say that, well, I mean, if an investor goes to the courts, should the courts be able to, instead of sending them back to the domestic jurisdiction, say, well, the state should go and enforce it within the domestic jurisdiction, should the courts be able to have a jurisdiction over that and deal with that? I think that personally, I think it's a very good idea, and I'm sure Anna will be talking to us about the business and human rights project. So it's something that probably links into that, and maybe you might learn some things from that as well to add to your paper. Now, I was going to say something, but that has been covered this morning. I was going to say, well, counterclaim, your paper was specific to counterclaim, and I agree with that. I think you did it. The paper was quite good, but you need to kind of go back and also have a look at why is it that the states cannot enforce it within their jurisdiction, because of kind of either you're not serious, laws are ineffective. So those are some of the problems. So you need to engage with that before you say, well, because of this, we need to have it done there. Now, what I was going to suggest is that, well, if the court is going to have jurisdiction over that, should countries be able to go there, initiate a case there without them waiting for a claim against them to counterclaim? So that would be a step further, but I know that that raises a whole other problem. So maybe you might want to stick to where you are at the moment. I've been showed 2 minutes a while ago, so maybe I will end it here. Okay.
Sorry. Yeah, I'm sorry. Sorry. Yeah, I'm all right. The next one is kind of.
Good recovery. Thank you. I have to actually admit, I think I've seen that before once. Okay, that's, sorry, excuse us. That was all recorded, wasn't it? So now we're on to the point of questions after the comment. So yeah, if we can have, are there any comments or questions from the audience? I'm sure there are. Martin, thank you.
I just have one comment, and then I'd love to hear your take on it. That is that, you know, with I'm talking about the inequality and equality chat. I think that it's very important to draw a very fine line between looking at that and not taking away the sovereign powers of state. And I say that keeping in mind that lobbyists have just as much power in the United States and the EU, as we know from COVID and the contracts that happened there, that is not necessarily only a matter that, you know, developing states face. That's the first thing. And the second thing is also just, you know, I do think that as much as we would like to have you know, differentiated treatment, I would rather, that is just my comment and my opinion, that I would rather have our ideas and our opinions being included than getting that special treatment, because it takes away from sovereignty.
I think my comment or question, or it's going to be a comment and a question at the same time, is regarding some of, I think the tone I've been getting from this conference that makes it look like African countries should, or there should not be an inclusion of African interest in this conversation. It gives the impression that the MIC is a very is a welcome development, but at the same time, not being able or not giving the opportunity to speak about things that concern Africa takes away from the African voice. If substantive issues like some of the speakers have raised is important to African interests, why should it not be discussed about, or why should it not be discussed in coming up with better solutions? Substantive issues are critical to Africa's interests. So while it's good to look at the procedural part, if the substantive issues as some of these papers have raised is not addressed, then it begs the question of why are we even discussing, or why should we talk about the multilateral courts as from the position that it might be beneficial to Africa. So the way I look at it, it's important to discuss these issues because it's with just saying that Africa should look at how this court is going to be beneficial to it is already making the assumption that it's going to be beneficial to Africa. And it gives the impression that Africa should always be the rule taker instead of being part of the rule makers. So I just wanted to clarify that point, that it's important to have this kind of conversations without making it look like everyone is just focusing on how Africa will get preferential treatments. I don't think it's the case. Thank you.
Thank you very much for two exciting presentations. I have really a question, and I think also now in the discussion it was reflected, we heard mostly about African interests. If I understood our first speaker correctly, he was identifying Sub-Saharan African interests being maybe different from other regional interests of African states. And I would just wonder in what respect they might differ from the rest of the continent.
My question goes to Richard, just a brief question. Is there a consideration that if these environmental and human claims are brought as counterclaims,
will the panel of judges in this court have the capacity to resolve and address those issues? Would you then have to make a requirement for the judge sitting in MIC to be conversant with the environmental and the human rights issues? Because that then would have to be a requirement first before those counterclaims are heard. Because I'll give you an example which you might go and look at. The East Africa Court of Justice, established under the East Africa Treaty. One of the requirements for you to be a judge in that court is that you must be a trained arbitrator, because the court metamorphoses itself for some cases to be an arbitral tribunal. So it then begs the question that in making recommendation, you may consider first also making recommendation of the qualification of the judges or the arbitrators to be sitting in MIC before your idea then is adopted. Because if it's adopted and the judges cannot resolve it, then we already have a problem. Thank you.
Thank you. I'm just responding to a provocative statements made not by the presenters, but from the floor here, that it seems like the conversations are not open to hear the African interests and so on. And I think, frankly, we really are missing the point here. And I think that's the discussion we have been having since the beginning of this workshop. So here is a problem, and the problem we know is about the system, and we are looking at the processes right now. Then you have African countries and scholars like yourselves who want to look at something different. That is fine. Table it at the appropriate forum, and then you will see whether there is a buy-in or not. And we are 54 countries, if I'm not mistaken. I mean, that's a lot of majority that we exert at the international level. But ask me what happens. They all keep quiet. You go to the UNCITRAL website now, you go to the work of the Working Group 3. There are less than 10 African countries that have made submissions. At some point, I was actually appalled by one of the African countries that made a statement that, listen, we need to see where South Africa is taking this. We can't really say anything right now. And I was like, what is this, you know? So these are the countries that we are confronted with, our own country. They are just sitting in these forums saying nothing. The only thing they can say is that, well, things are imposed on us. By who? I mean, you are unequal, all right? The fact that your GDP is low does not mean that you cannot think like other people can do. I think we need to get our act together as African countries and scholars, and we need to step up to the plate. We cannot plead colonialism right now. I mean, who was not colonized? I as a scholar usually feel insulted by our governments when they say there are no skills. I say, I've got skills, all right? And there are ways in which they even, you know, appoint the people who go and represent themselves in these forums. You've got to have a political party of a sitting government for you to be appointed to go and be in Geneva or in New York. And so, and European countries, they are serious about their economies. They will not do that. They will, sorry, I'm ranting, but I think it's important, because then we'll keep on falling into the same trap. By the time we wake up, yes, we will be rule takers. We need to influence the rules right now. We've got skills in this continent. We just have to put the right people at the right places. We cannot continue using the political party representation when we appoint people to go and represent us in Geneva. Right now, with 54 countries in the UN, we should be, you know, steering the discussions at the direction that we want, but we are not doing that. Thank you.
Just sorry, on you're going to get you will probably even over lunch get a lot of questions around the colonialism and neocolonialism. I want to bring up one point that I think you should look at, and that is the place of the bigger economies within the regional economic communities, because they are steering the discussion on the continent itself. So you will have South Africa, you'll have Kenya, you'll have Nigeria. And I think perhaps the inequality there and how we are dealing and resolving the inequality should filter through at that level. That is from where we need to start and then move on as well. Make sure that, you know, we are democratic in our processes and democratic on the international setup. So maybe just that might be an interesting one at least.
Thank you, Martin. I have two questions, one for Robert, another one for Richard, but I have also one comment between this distinction between substantive and procedural reforms. Because when we look at even the submission of the South African government to the UNCITRAL, they say they cannot distinguish between the two. And if we look at it, it's full of the two kind of submissions. So sometimes I think in the interest of the discussion, we can focus on the procedural, but if some people feel comfortable to bring also substantive reform, we can also listen to it. So my two questions now, one for Robert. I think one of your recommendations is to look at the way WTO judges are appointed as a model. And I don't know if that's a very good example, because currently we are witnessing a crisis at the WTO appellate body level. So I don't know if that's a very good example. And for Richard, I don't know, I didn't read your paper, so maybe you talk about that in your paper. But in the context of ISDS, there is this interesting case, Uruguay against Argentina, in which the first human rights-based counterclaim was accepted by the court, so at the tribunal. So I was wondering maybe if you look at it for some argument, because the investor was saying no, and the court, the tribunal retained jurisdiction over the human rights counterclaim. So maybe you can look at it. What are the reasons why it has accepted the counterclaim? And also, it's true that at the end, the counterclaim failed, but I think it can give you also something. And even the Pan-African Investment Code that you mentioned, I think there is a specific article for counterclaim. So maybe those are the elements you can also look at. Thank you.
Okay. I think we're at the point where we should be getting comments from our presenters, responses, etc. Again, I think it's the case that there's too much to be able to fully respond to there. But I'd like to give you each a good 4 minutes to pull out what you'd like to do. Robert, are you happy to go first?
Thank you for the comments and the questions. I believe the comments will be really useful in changing the perspective and improving the argument in the paper. Whether the question on whether differential treatment would take away sovereignty of the nations, well, I'm not sure, but I doubt in the what I mean by differential treatment. It is not to try and look at Sub-Saharan Africa as needy and as people who, maybe to use the words in one of the comments, people who are not able to think for themselves. But it is just to consider that it is a fact that these nations are at a certain level economically. They have a particular history that would inform their approach to dispute resolution. And within the procedural aspects, there are certain procedural recommendations that would be interpreted to favor a nation in that kind of a situation. For instance, if we take the issue of costs, as I had mentioned, that there are certain approaches that we can take procedurally to ensure that costs are not disproportionately affecting nations that are in this particular region. But I have gotten that aspect of sovereignty, which will also inform further my reading. And what are these interests that are unique to Sub-Saharan Africa? Well, I wasn't particularly comparing Sub-Saharan Africa region with the rest of the African region, but with the other developed nations outside Africa. Only that now the theme of this conference was focusing on Sub-Saharan Africa. It may be the case that certain interests in Sub-Saharan Africa are shared by other nations in Africa at large. And maybe just to finalize the last question on WTO, what I was speaking from WTO model of appointing judges, there is the provision that where a developed, there is a dispute between a developed and a developing nation, then there is a provision that the developing nation would request the panel to have a member from a developing nation to sit in. You see, that is also an appreciation that there is an interest of developing nations that would be taken care of if we have another member from a developing nation. So there may be issues that maybe there are somehow issues of perception, but again, justice must be done and seen to be done. Well, thank you for those comments. I'll stop there.
So thank you so much, Emmanuel, and for the very illuminating comments and the questions, and all those who also have commented and asked questions on my presentation. I think some were comments, so they have been noted, but there was a question whether from Emmanuel, whether why is it the case that, oh no, that was a comment for me to look into, why states have not enforced human rights issues maybe internally. Is it not that maybe they're not willing? So the problem is not maybe tribunals, but the states themselves. But there's a question whether procedurally now, a state should be able to say, we think you are violating human rights and this is beyond your rights as an investor. We are commencing proceedings against you before the investor commences an action. So I think in my view is we're trying to balance the interest of the parties here. So I think in principle, I do not see a problem with that if it can be provided for procedurally in the rules of the court to say either party to a dispute, but maybe you have to make sure that there is indeed a dispute on that. So maybe a state may engage the investor and say, I think you are doing this thing wrong, so I want to stop you from doing this. And the investor says, no, it's within my right under the investment treaty. If you're stopping me, you are preventing me from enjoying my right. There's a dispute there. So if they fail to resolve, yeah, I don't think there is any principle that would be offended if it is the state that will go first. The second question was about now the fact that these are areas of law that are outside pure investment law itself. What about the judges? So yeah, this now will speak to the qualifications of the judges, and I'm sure there have to be obvious areas of specialization will be there, like international investment law, maybe international dispute settlement, even public international law, general public international law. Yes. Now with this suggestion, I think yeah, some of them will also be experts in maybe international environmental law. As a public international lawyer, you have that expertise, but maybe should there be maybe cases where the bench sees that maybe the expertise is lacking, I think it would be good to have a rule that we empower the court to maybe seek experts' opinion on certain legal or factual issues to take into account in dealing with the case. So yeah, so I think there should be that open, it should be open to the court to determine itself, to say, we think here we need assistance or we can deal with this on our own. And thank you so much also for bringing to my attention the Argentina case. Yeah, I haven't read it, so I will look into it at an appropriate time. Thank you so much.
Okay, thank you. And I think there's some real nice examples of collaboration amongst junior scholars, as well as, of course, seniors and others there. So that's lovely. So thank you very much for the panel. I think that brings us to the end. I would like us to get up carefully from our chairs at this point. And I'm not making light. I really hope. Thank you so much for recovery here. And I think my suggestion is does Anna come forward and speak at this point?
We'll keep rolling. So 22 minutes behind time. Yeah.
Can Anna, is that good for you? Okay, great. That applause was for Marc. Now for the panel. Thank you.
Okay, I think I start already. Can you hear me? Before I get the mic and move. So thanks so much to okay. Again. Thank you. Thank you so much to the organizers for giving me the opportunity to talk about the Hague Rules. So what you see here on the slide is the Peace Palace in The Hague, where the rules were launched in 2019. Now, what's the motivation for those rules? Why did we think about doing them? So the first problem we have is how to prevent human rights abuses by foreign companies in trade and investment. And the second is how we can remedy those human rights abuses. And those of you who work in the sector who know that there is this third pillar of the UN guiding principles, which is the weakest pillar in realization. So, of course, those two problems are interconnected, because if the remedies are weak, prevention is also likely to be weak. So the question we faced was how can we integrate human rights in the operation of foreign companies? And there are multiple ways to do that. You can think about substantive norms, but we thought the main issue is, of course, on procedures and effectuation of access to justice. Now, this is what I would quickly like to talk about. I would like to map the field a little bit. I was changing a little bit on the slides, but now those are the old slides, but it doesn't matter. The context and the history of the Hague Rules, the main features of the Hague Rules, and the applicability, and then discuss some challenges and potential of the rules. Now, what you see here, and I'm going closer because I think I need new glasses. So what you see here is I'm trying to map the field with substantive norms on the national versus international level and soft and hard law. Okay, what you see on the international level is, of course, the UNGP, and the Hague Rules are based on the thoughts of the UNGP, the guiding principles. You have the Global Compact by Kofi Annan, you have the OECD guidelines, you have the ILO tripartite declarations, you have the SA 8000. So there are a lot of soft law norms for business contact, but they're all soft. Now, on the hard law level, you have, of course, international human rights law, but of course that's state-centered. You have could have human rights norms, and that was just discussed in IIAs. and that's coming. And we have the ongoing negotiations on the Business and Human Rights Treaty, which would be hard law, and it's unclear whether that's going to be more state-centered or take the intermediate approach, or business-centered, so direct applicability to business. Now, on the national level, you have a lot of, and I put here Germany, we changed, but we had for a long time national voluntary self-reporting obligations. You can use nudging measures, and on the hard law side, you of course have private law side, the supply chain contracts, which do contain human rights obligations for your contractual partners. And then of course you have public constitutional criminal tort law, and you may have national due diligence legislation, and of course the EU regulation is also coming. Procedures. International soft, we have the OECD national contact points, and we have reputational mechanisms, for example, which basically is the global compact. We have human rights courts, potentially ISDS, you have all discussed it, so I'm not going to go there, and single industry accords where we already have arbitration, like the Bangladesh Accords, which came into place after the Rana Plaza events. And this is where we come in. So it's on the international level, hard law in the sense of hard procedures, so business and human rights arbitration, which could be business to business or victim to business. Nationally, we have national courts, again, B2B or B2B, and we have arbitration B2B usually. What was the context and the history of the Hague Rules? So the challenge was, and the question was, can arbitration overcome some of the legal and practical barriers faced when bringing human rights claims through the existing mechanisms of redress, particularly national courts? Because of course, national courts are the first best option, but we also know that they oftentimes do not work. Now, here was a working group of basically a few people, 3-4 people who saw the problem, including general counsels of multinational companies. And they had this working group, which then we formed a drafting team under the chairmanship of former ICJ Judge Bruno Simmer. And we were about 15 people, very diverse from the background. So professors, practitioners, human rights litigants, so lawyers who do the litigation, including here in South Africa. So we were meeting for a lot of times in The Hague. In November 2018, we came up with an elements paper, and the first consultation round, we had a very broad sounding board of people so we started with NGOs, with states, with business, anything. So in order to get as much feedback as possible, in 2019, we had the draft rules and another round of consultation, and in December 2019, that was launched in The Hague. The PCA will be our institution where to base. So they will be the institution to administer the rules. What are the main features? We have the rules of procedure. I mean, that's the rules. We have a commentary to that. We have model clauses. We have a code of conduct for the arbitrators. And we think about adding more model clauses now because we keep on work ticking. So work was not finished 2019. It's based on the UNCITRAL arbitration rules. Was this me? No?
Well, this microphone is off. So.
Okay. On the UNCITRAL arbitration rules, the thinking behind it was a bit also that the business is very comfortable with the UNCITRAL rules. They know them. But we work with flexibility, adapting to human rights concerns, relying on the UNGP third column, so non-judicial remedies. Let me say that when we worked on that on certain issues, like for example, transparency, we looked at the ICC rules. What about victim protection and witness protection and all those things? So we consulted very broadly on procedures, but UNCITRAL was like the main basis on which we were working. So we tried to find a balance between the parties, taking into account potential imbalances of power. Parties, as I said, could include business, individuals, labor unions, states, IGOs, NGOs. They're consent-based, of course, they're arbitration, it's always consent-based. It could be given ex ante or ex post, and the scope of the consent is, of course, very important. Specific expertise, what are the main features? We ask for specific expertise and qualifications for arbitrators, as well as a code of conduct, transparency, which is the default, but there are, of course, exceptions, for example, for witness protection, but also for business secrets. Taking the evidence, where we try to strike a balance among the number of factors, notably fairness, efficiency, cultural appropriateness, and rights compatibility. Protection of parties and witnesses, I've said so already, participation by third parties, including amicus curiae, which are allowed, including eligible countries with a sufficient nexus to the dispute. So certainly, for example, the host countries, and possibilities for joint and multi-party claims, because as you know, some of the human rights violations are really large scale. So you need to find some possibilities for that. What's the applicable law? Again, here we opted for flexibility. In any case, all the rules are flexible. They're default rules. Their substantive standards can stem from a variety of legal instruments. So it could be could be domestic law, it could be supply chain contracts, if you have, for example, a B2B dispute, could be human rights treaties, could be soft law standards. The important thing is that any award needs to be rights compatible. Costs. That's a big issue because we know that it can be very expensive to arbitrate. So the tribunal can depart from the loser pay principle. It can take into account economic balances. What is clearly desirable is legal aid. It would be a legal aid system, depending on whether there's any attachment of the rules to a certain institution. Contingency funding or an agreement on the asymmetric distribution of costs and deficits between the parties, ex ante. Okay, so those were the solutions we could come up with. You can think about others, and again, think about where they get attached to. There's also an expedited procedure to disclose claims of manifestly without merit as a preliminary stage, and those should remain confidential. The reason for that was that we didn't want to have any how they are called in the United States, the class action suits, where you will not succeed, but because of the potential reputational loss for business, they would settle. Okay, so in order to avoid that, we wanted to keep that one confidential. Applicability, disputes between international companies and affected right holders directly. So this is really a means to get the money to the victims. So it is about liability. It can be combined with ISDS. It's so foreseen in a contract, so in an investment contract, including there, business could have an interest to take care of its obligations under Pillar 3 of the UNGP, or in an IIA. As you know, the investment protocol for the African Comprehensive Free Trade Agreement is negotiated currently. The zero draft is leaked. In the zero draft, what you have is liability for investors. But you have to go to the home state of the investor. I don't think that's a very good idea. That's not an effective remedy for most of the victims. So if they're serious in having investor obligations, and they're not the only ones. You might want to think of attaching the Hague rules. We are in contact with them. We hope that they will take this into account, but I think there are so many contentious issues that they might forget about the Hague rules, which would be bad. So we hope that would be something. It seems that the Gambia has the Hague rules in its model BIT. We are trying to get hold of it. There was a publication about it, but they keep their model bit secret. So we're still trying to get it. If anybody has access to it, please let us know. That would be incredibly helpful. And then, of course, last but not least, where is Colin? We hope they might want to attach it to the court, to the idea of the multilateral investment court. Because again, if you think from the perspective of victims, you want to give them the maximum possibilities of effective access. So arbitration could be one. And from the business perspective, arbitration may not be the worst possibility, certainly compared to national courts. Now, disputes between companies and their suppliers on non-compliance with contractually stipulated conditions in the field of business and human rights, that's another possibility, but much more. So they can be used in multi-stakeholder arrangements, like in the Bangladesh court. You could have that in international development finance agreements. So I would hope that MIGA, for example, when giving an insurance, say, well, of course, company, we are happy to give you the money and insure your investment, but maybe you want to think about fulfilling your duties under Pillar 3. So please do give your consent to arbitration. And that they can confine it. That's why I'm saying the scope is important, but they could, for example, confine to the local communities affected, right? That would be a credible commitment. Public procurement contracts, etc. It can also be offered by national arbitral tribunals. I think the important thing here is to note that this is the first arbitral procedures which take special care of human rights violations. And you cannot do this under the UNCITRAL rules. Now, what's the potential? We think it can address the responsibility to respect, so the second column, and of course the third column of the UNGP. It's a consent-based instrument, but it's flexible and it's adaptable. It's an instrument for reparations for victims, and this is where we have fallen short, or hitherto at least, even though we have all this national due diligence legislation coming up, some of it with civil liability. And of course, we are doing all this in the shadow of the EU regulation for the European Union and the Business and Human Rights Treaty. So again, here, I just saw a doctoral dissertation which said the UN Business and Human Rights Treaty should also integrate the Hague Rules as a second possibility. We are also in contact with them, so let's see. So much depends also on finance, the private and the development banks, how far they ask when they do project finance, ask the companies to somehow fulfill their duties under Pillar 3. What are the challenges? Of course, the problem of acceptability, because you need consent of business and acceptability by states, potentially, as well as the human rights community. And we really try to find a good balance between all of those interests. And which I don't want to deny, there's of course a problem of inconsistent decisions. We hope that transparency should mitigate that problem, and the PCA as the managing institution would also, just as ICSID does it, publish as far as it goes. I mean, depending on what sort of interests have to be blackened, but otherwise it should be public. Certainly if it's victim to business, if it's business to business, they have easier opt-out mechanisms. Okay, that was it from my side. And thanks so much again for giving me the possibility to present that and ask any questions, comments, suggestions. Thank you. And Martin, you have to say how many minutes you have.
20 minutes already over time. So there's got to be a balance reached here because there is a hard deadline this afternoon. Many of you have to take flights at various times. So we've got one or two options. Either we stop now and then perhaps over lunch you can engage, or just 5 minutes now and then. But I leave it to the host. All right, Jonathan. So let's just bear in mind that
we do have a really tight schedule.
Hi, thank you for the presentation. Just a very quick question. I probably missed it at the beginning, but what's the current status of the development of the egg rules? Where are you at in the process?
Oh, the rules are there. They're out there. So if you Google Hague rules, you'll find the website with all the materials on it. Okay. And now it's for everybody to use. It's also on the website. Everybody who has been in the working group, all the names are on the website. I didn't want to put it all in the slide because otherwise it takes more time. So I was, Anna wanted to say something? No, I passed. Okay. Yes, okay.
Just quickly, I noted that you said it's applicable to victim to business. But yeah, I remember, I think 2000, during one of the consultations, I had some kind of exchange with Steve Ratner. I think at the time it was seen mainly for business to business, was it? I'm not sure, when it's kind of not.
No, I think, well, when I joined the group, which was pretty much when the group was formed, already the scoping papers of the original working group, they had business to business and victim to business.
Oh,
both.
okay.
Both. And yeah.
All right. Okay. So how do you deal with consent? Is it for a victim to go against the business? Where do you get kind of consent of the business to agree to arbitrate?
In a way, it's the mirror image to what we have in ISDS, right? So it would be the business giving the consent ex ante, but it can give it ex post, but it could give it in a finance contract, for example, or in your the investment contract, which you have with the state, right? And there, because business will be reluctant to give an overall consent, oh, just go ahead, sue me. No, they are not going to do that, but they could define the groups where, for example, the local communities say, well, if there is anything, we go to arbitration, okay? So that they could do.
I guess I just wanted to ask, congratulations on it, Anna, it's great. But have there been instances of arbitrations? I know you think that the rules are in a model BIT that you can't yet get a hold of, but are there arbitrations that have happened?
No, I can answer that quickly. Till now, we don't know of any arbitrations. We know of a lot of institutions who are looking at it, including human rights on sea, which is a big issue, all the seafarers, where you have a lot of human rights abuses. So they're looking at those. And then they might just take them and modify them, and then we had this discussion, well, do we have something like a copyright to those rules? And I said, no, and we don't even want it. If they take it, and if it helps some victims, this is what we want. So whoever wants to use them, they're there, can say, well, it's useful for us as a template, we can deviate and they can use it. So till now, we don't know whether they were used. Maybe they were used in that form or any other form, but we haven't had any feedback on that. Okay. But I guess it takes time, there was COVID and now we keep on working. So think about the rules when you have those cases, right? Okay.
I think we might, because we do have another panel and we have another keynote speaker at the end, Michael. So I have to cut it short here. I'm sorry, but everyone obviously needs to present their views. So let's take lunch now. We'll have to have a short lunch break, 45 minutes. 40 maybe. Can we? What time do they come back? Yeah. So basically, we can restart at 1:45. Yeah. That's there. 1:45 to 2. All right. Well, let's move. Thank you very much for the panelists again.
Oh, sorry.
Hi. You know how busy I am. I can't do 2 jobs. Can't do 2 jobs. Yeah, today it's working. I actually need to change in this circumstance. Do you want it on a Word or PowerPoint? Let's do it on a PowerPoint. Yeah. Okay. What's the title?
The Multilateral Investment Project.
How do you spell that? Multilateral.
Investment.
Investment.
Project. That will, how do you call it? A dangerous travel. A dangerous. Or a safety net.
Or a safety
net. For African states. In investment dispute settlement.
Investment
dispute settlement. All the first word in how do you call it? Majuscule. Like big character.
Here.
For all the first word.
Oh, when we're typing.
No, you can leave it. Like, a safety
for African states.
Investment. Yes.
Settlement. This one.
Yeah.
Okay. I'll save this. Yeah, the last one. Okay. Hi. Yeah, I got the latest one. Yes, I've put it up. Master. Yeah, so we had a little bit of a glitch, and the first one, I'm sure you'll see. Well, you're not gonna watch the thing anyway, but just to let you know. Okay, in case you get questions. So one of the presenters during told me it doesn't have slides. It can just talk. So I was praying. I walked out of the classroom. I can't get the find.
So you're just looking at the sequence. Well, yeah, the next no, not critique, understand them.
To address when the treaty is down, Pat. You get this. You get the feeling, however, perhaps a compromise would be to have a court that moves around the world somewhat. It's not so localized, and it is. Yeah. Potentially, but there'll be a fight over where that appellant court is.
Not in South Africa.
You want to travel? Well, speaking of traveling, Afolka Dedeke has traveled all the way from Halifax to be here, and I know at certain points that the jet lag really does catch up with you. Hopefully, you're still on board with us. Fola is formally a professor here at the university, but now has taken up a position in Halifax. You might give us a few details on what that is, and then launch into your commentary.
Thank you. I guess I moved from being a full-time academic to a part-time academic. So in Halifax, I'm in private practice now, focusing on international economic law and data protection. Thank you both for your presentations. I think Martin rightly pointed out that the two papers complement each other in terms of the theme and in terms of a recommendation. And your proposal, which is for the establishment and operation of the MIC through the African Continental Trade Protocol, is a concept that I slightly struggled with. And so I'm going to talk through my comments, and hopefully during the conversation, I can get some more clarity about how you envisage this happening. So in Colin's paper, you start off by conceptualizing the issues around development and focusing specifically on sustainable development. And then you address issues related to the legitimacy crisis of ISDS. And then try to make your justifications by focusing curiously on the issue of African countries and the debt burden. And then spoke about African countries as rule takers and the role of the African elite. I'm going to address these main features of your paper independently. So in relation to the development dimension of the MIC, that strikes me as a substantive issue. And we've had several conversations over the last 2 days about, what is the focus of this workshop and the focus of working group 3. We are focusing on procedure and establishment of the MIC. But I guess what we're trying to do there, and correct me if I'm wrong, is to effectively lay out the need for the MIC to be established along the dimensions of, take for example, the European Court of Human Rights, because you keep referring to the European Court of Human Rights as an example, suggesting to me that you see it as a potential model that should be adopted for the establishment of the MIC, but you didn't quite tease that out and zone in on why you think that the European Court of Human Rights could potentially be a valuable, I guess, comparative to be considered in the establishment of an MIC that has this developmental focus. But then when it comes to the question about the legitimacy crisis that confronts ISDS, these are old issues that we all know about, but there were some curious takes in there that I think perhaps we should push back a little bit on that. So, for example, we keep hearing, and not just from the presentation by Colin, but from other scholars who have presented today about this idea of effectively suggesting that African states don't have agency, and that some of these things that are happening, it's because African states are being forced to adopt rules and be forced to participate in bilateral or multilateral processes that they can't necessarily, they don't have a voice in. But then, there's very clear research out there, that shows that, African states have been contributors to the norm development in international investment law. A scholar that I might want to consider, Bisaka Kabre, described African states as reverse contributors. And what it was trying to, it referred to African states as reverse contributors because African states have primarily been respondents in existing ISDS cases. But the fact that you're a respondent state does not mean that you haven't contributed to the development of international investment law, because certain arguments have been presented in these existing ISDS disputes. Some of those arguments have been accepted, some of them have been rejected in arbitral awards. But you need to be careful about the framing of African states not necessarily having agency in the current system and in the future system. And there are also several cases where African states have particularly participated, where you see a clear development of international investment law, which was advanced by the states. Holiday Inn versus Morocco dealt with a very old case that dealt with the binding nature of illicit arbitration and how states are to be treated as a national, investors are to be treated as nationals of contracting states. You have Salini versus Morocco, which gave us the Salini test, the World Duty Free versus Kenya case, which deals with the rule of land anti-corruption, and of course, Bywater versus Tanzania dealing with transparency and amicus participation. And then the main argument to make to justify why the AFCFTA would be a viable means for the MIC relates to this notion of the debt burden that African countries have. And I'm not particularly sure that that's necessarily a powerful argument in suggesting that because African states have a very high debt burden, then it makes their experience unique within the investment law space. I think there are, several other fantastic examples you can make to justify why, a developmental dimension for MIC could work. But also just remembering that, the African experience in ISDS has also provided some notable shifts in domestic regulation. So it was, for example, in the South African case, it was shortly after Peroforestry that you had South Africa make the decision not to renew its BITs with some European countries. In the Nigerian context, the P and ID case that is still ongoing on, but at the enforcement stage in the UK has also led to some interesting conversations in Nigeria about, rethinking domestic regulation there. And then, the whole notion about African countries as role takers and the role of African elites, there seems to be some homogeneous take there that I think you need to be very careful of. You make, very strong arguments about the role of African elites, which I don't think that, when you speak about the role of African elites, I'm assuming you're referring to state capture, basically, but I don't think that state capture is necessarily a problem, especially when it comes to the issue of enforcement of resolution of investment disputes, because we know that, companies actually thrive in corrupt environments. The biggest issue in relation to the resolution of disputes that causes disputes in the first instance, I think, is regulatory uncertainty and the instability of governments posing more of a challenge, and not necessarily the fact that governments are corrupt. And then, I guess the main recommendation you're making is that because of this developmental dimension that you want, the doctrine, what to call, refer to as the remission doctrine, should be used as a means of referring disputes to under the AFCFTA. And there's this specific statement to make in your paper. The remission doctrine simply means that MIC should remit any compelling regulatory issues to host state institutional competence in similar fashion as the ECTHR, rather than adjudicating it. Which begs the question, and what's the point of the MIC? It seems you're suggesting that, the MIC should simply serve as an institution that refers cases under the African investment dispute system under the AFCFTA, and then that should be dealt with at that African level. Which brings me to Ijeoma's paper. Thank you for your paper and your presentation. Your paper, I guess in similar fashion to Collins, captures the essential elements of the MIC. You look at the institutional architecture, the likely outcomes and potential challenges. And then you conclude with the recommendation for an Afrocentric dispute settlement system, which again to me suggests that you are saying that, we probably don't want the MIC, we want something else. And I might be wrong, but I think the essential research question in your paper was, why is the current process problematic? And how can it be fixed to be fit for purpose from an African state's perspective? And to be able to, I guess, answer this question, very briefly, because you deal with this extensively, and I think it should be slightly shorter. Identify the current problems of the existing system, which we all agree on, manner of selection of arbitrators, lack of transparency, potential bias, inconsistency in decision-making, rigid amicus participation rules, and then, the lack of influence of other fields of international law and the like. But then, but the main focus should then be on how can the MIC fix this, and I think you are concerned with two main things. One, the current process that's going on in working group 3 and what the eventual outcome would be. But and for the current process, there are some interesting things that you allude to that I guess could potentially flesh out. One relates to the question of the ongoing consultation process and how that can be more inclusive if you've identified any particular problems with the current participation process that you think is not reflective enough of concerns that African states have, and why you think there should be more inclusivity. Curiously, for both papers, and I should mention this, outside of Jonathan Kabre, I think everybody else, you when you're dealing with this, with your papers, you do not address state submissions. There are about 10 states that have made submissions to the MIC, and I think there's some very rich content in there that could potentially give some indication of, what states are thinking in relation to some of the issues you're dealing with. So for the issues that you are raising here in relation to consultation process and inclusivity, the constitution of the courts reflecting this, I think, reference to some of the state submissions could have assisted you. But in your paper as well, I'll read this specific paragraph out where he said, the success of negotiating the MIC system of dispute settlement the MIC system in its contemplation must reflect the Sub-Saharan African legal system and ideologies, and the AFCFTA is therefore a great platform where Sub-Saharan African countries can speak with one voice. And I guess that is where you're effectively suggesting that maybe Africa should not participate in the MIC process. Because you refer to the Africanization of investment law, focusing directly on the Pan-African Investment Code, and in the presentation you gave now, which I guess fleshes out your ideas a little more, because it was after you wrote the paper that you looked at the investment protocol. You suggest that the FCFTA has these substantive provisions that are relevant to us. But within the protocol itself and within the Pan-African Investment Code as well, the dispute settlement provisions in there are not necessarily different from what is proposed in the MIC. The only thing that I can see that is perhaps unique in the African documents, is the provision for counterclaim. But other than that, it's largely consistent with ideas currently being discussed within the working group 3. So what exactly is different within the dispute settlement provisions in either the Pan-African Investment Code and in this linked investment protocol that you think makes this a more worthwhile process for African states to follow? But from what you are saying, I guess a way to potentially address these issues are saying, because both of you seem to be very focused on the importance of bringing substance into this procedural conversations we're having, is perhaps you might want to explore further this idea of special chambers within the MIC that can potentially focus on these unique issues that you think would make African states more interested. Thank you.
Thank you, Fola. Questions and comments from the floor? Any thoughts, comments out there?
Thank you. I think my question would be to Collins. How do you perceive that we'll be able to incorporate pro-development issues within the statute of the Multilateral Investment Court, considering that it's a procedural matter in itself, so we can't, so to say, bring in substantive issues. So how do you go about incorporating pro-development ideas?
Thank you for that question. I think that that is not going to be a problem. What is important here is the commitment of the proponents and the supporters of the MIC. So in this kind of situation, what is necessary just to include, let's say, a chapter or a sub heading that will be couched in such manner. And as I highlighted before, it is not necessarily for the the language or the tone, the how it will be, constructed is not necessarily going to mention Africa there, but it just, couched in such a way that Africa is comprehended, in the sense that basically it will affect Global South generally, not necessarily African countries. Okay, if you look at if you look at, I think Article 25 of ICID is in definition of investment, and regarding the jurisdiction of ICID, you see something relating to that, where you see a mix of substantive and procedural issues taken together. So it's not going to be a problem, to cut the matter short. Yeah. Thank you.
Okay, I would like to thank the two presenters for the presentations. I have a quick one for Ijeoma. I think you mentioned, or you referred to, the AfCFTA protocol on investment. And I was wondering if you are talking about the zero draft or the protocol itself. I think it was adopted a few weeks ago, and it still has to be formally endorsed by African Union officials. But if that's the case, and if you have it, I would be more than happy to have a look at it. Yeah, thank you.
Who else?
This is more a comment, and I just think we need to be just a little bit aware of the extent to which what we are agreeing to at the AfCFTA or any of the regional economic communities, quite a lot of what is put on paper is taken from elsewhere, as is, without any changes made to it for ourselves. And that is one of the critiques that we have for ourselves, that we don't adapt enough. We don't make it ours. And so just be very aware of that. You will always see those, you'll see certain sections, and then it is very important to also highlight the ones that are problematic, because at the end of the day, we want to make sure everything's better. But yes, the technical seniors, the senior technical people have agreed. Still has to go back to the capitals.
Okay, thank you for your question or comment, and I thank you for your observation as well. So like I think I mentioned it, that the protocol is not an official one, but because we're talking investment, and my proposal is such that the advocates of MIC should, be in discussion with the AfCFTA, since the protocol on investment is, the negotiation on it is ongoing. This is a good time. At the time I wrote the paper, I hadn't looked at what the protocol, had, contained. But I just felt that Africa, I want to believe that we speak in one voice, and it will be difficult to be discussing with African nations individually. So, but if you discuss with AfCFTA and they buy into the MIC thing, it will be easier to get Africa on board the MIC. So it was in that context I discussed the protocol. It's not official yet.
Okay, well, I think we might move.
I have something to say, please, if possible.
Of course, it's possible. Please, Collins.
Okay, this is just a bit of clarification regarding concerning what my moderator said before. With regard to debt issue, the relevance of debt issue regarding MIC procedural rules, it is to highlight the precarious nature of African countries requiring special provision. That is the basis of that debt-related issue. Now, with regard to African elites and its relevance to the matter in question, under the current ISDS, there is still this ongoing issue as to whether IC should take all matters emanating from a host state institutional environment. So why I highlight, and also under the national juridical system, it is possible for some courts to decline jurisdiction in respect of certain matters before them. So what I did here is to highlight the pitfalls for MIC if it fails to take these situations into consideration. Now, with regard to the third issue you mentioned about remission doctrine, this also relates to the second issue. Is linked to the second issue. It's also the extant legislation in ISDS is also filled with this kind of issue as to whether the adjudication should be remitted to, should be handled at the IC level or otherwise. So what I'm trying to do here is to highlight slippery areas for the framers of MIAC to avoid repeating IC mistakes. Thank you.
Thanks, Collins. Marc, do you have your hand up? No. All right, well, I think we should move to the last item on our agenda. While we set up for that, we've heard a lot of thank yous and even apologies over the last 2 days, but the biggest thank you has yet to be given. And you're probably wondering, well, how did we miss that one? There is a funder behind this scientific event, and it's the Volkswagen Stiftung. And when I was writing the application, one thing that I had in my mind was that you don't want to put on a workshop where you say, we're having the workshop, it'd be nice to see you there, good luck. Maybe you'll make it, maybe you won't. The idea was to make sure that everyone from our keynote speakers, senior scholars, junior scholars, could get here and make a contribution. And the Volkswagen Stiftung supported that idea. And I think we are obviously really very, very grateful. They are not here. They contact me, however, and ask, how's things coming along? And I say, well, we're having I sent them the workshop program the other day. They were quite happy with that. So yeah, I'd really, even though they're not here, thank you to the Volkswagen Stiftung for all of the money that they've put into this. Hopefully they might hear the recording at some point in the future. Yeah. Well, the fact that you're all here in front of me now makes it worthwhile. No, I've enjoyed it very much. So, but there is one big highlight on the agenda. I don't want to put too much pressure on you, Michael, but can I invite you to the front? And I want to give you a proper introduction. So, I shouldn't just say Michael. I suppose I've become so familiar with you over the past couple of days, but I think the correct title would be His Excellency Ambassador Dr. Michael Imran Kanu. Sorry?
That's for you.
Oh, okay. So as I'm just reading off the program here. So Michael is the Deputy Permanent Representative for Legal Affairs at the Permanent Mission of Sierra Leone to the United Nations. And he's also the head of the delegation of Sierra Leone at UNCITRAL Working Group 3. So Michael, the floor is all yours. I'm going to run down into the crowd.
Thank you, Martin. That's quite a mouthful. I had to learn how to pronounce my function when I was first appointed because it was just too many words. So, good afternoon. I am between you and your hotel beds or your flights, so please bear with me. It is indeed a great pleasure to be here, particularly at the Mandela Institute. And so allow me to kindly extend my deepest appreciation to our host for the generosity and of course the kind hospitality. I must mention that the food has been great, so we should have that on record. Let me also thank you, Martin, Jonathan, and Emmanuel for the kind invitation to be here, essentially to share perspective, an African approach to the proposed multilateral investment court. And as you can suspect, that's really the title of my talk. I'll join you, Martin, in thanking the funders because essentially they brought me here. So I think I'll just join in saying thanks to them. As you've rightly introduced me, the lead delegate of Sierra Leone to UNCITRAL Working Group 3, but I also have the honor to coordinate the African group. It is an honor, but also a difficult task. Difficult in the sense that we should coordinate at New York level, Vienna, and capital. So I only coordinate one aspect of the delegates going to Working Group 3, and so it's challenging, as it were. And the objective is really to try to reach agreement on common African positions or common African position on ISDS reform. We have not been able to reach that objective yet, but what I can say is that the coordination mechanism has provided the space for communication, and so it has been of great value in terms of the participation and to table issues of interest. Yesterday, Martin introduced or spoke about the issue of damages and compensation, and that is one issue which, with a united voice, calling for the Working Group 3 to pick up the issue, we're able to get the Working Group to agree to address the issue of high amount of compensation and increased amount of claim, means to address discrepancy between claim loss and our damages, including excessive claims and divergence of expert damage calculation. So that's a sort of a huge success given the way in which the mandate of the working group has been interpreted by a number of delegations. But before I really get into my talk proper, please allow me to complete my thank yous. So I should really thank the scholars for your papers, presentations, and engagement in the past 2 days. I must agree with Colin that engaging with academia is always useful and important for us delegates. And so I look forward to more engagement, and this could be done using technology or other means which are made available, including the academic forum, which provides collective support to Working Group 3 delegates in terms of supporting our deliberations and providing ideas, solutions. That is useful, but for an African delegate, this has been most useful and beneficial to really listen to African scholars. So I've been mostly in listening mode. I was tempted yesterday, I asked a question, but then I decided to just listen and of course, offer my views in this closing keynote, sort of a reflection for the 2 days. And so you've provided interesting ideas, reinforcing approaches which we've thought of, discussed, or proposed, but also you've provided a lot of food for thought. I can summarize what you've presented thematically to cover issues of representation, diversity, accessibility to the multilateral investment court as proposed, but also ISDS, issues relating to transparency, and most certainly legitimacy. I will return to these issues shortly, but I must say that a bit has been said and there's been a bit of focus on the substantive rules or standards. And I really understand this level of interest. And I think it's also a shared sentiment in terms of the African delegates to Working Group 3. We will need to find a space to discuss the substantive issues. The ILC is not ready to do so. I'm not putting you on the spot, Professor Reinich, member of the ILC. But indeed, it's a huge concern. I was going to say a few words on the UNCITRAL African Days, but we've heard from Madam Secretary, so I'll just move on and save us a bit of time. But just to say that I'm happy to be here. Just last week, I was part of the Sierra Leone African Days series of events. So it's good to see that there is excellent implementation and overall success for the series. Now, let me get into a bit of my topic. And I will say that's been helpful to also listen to you, Colin, yesterday when you shared views on the origins of the idea of a multilateral investment court. and certainly coming after Madam Secretary on the work of UNCITRAL in terms of past, present, and future, it means that I can only focus on the African-specific issues. I don't have to argue everything about the court. So a lot of work has been done there already. But I'll go back to this issue of the original idea and whose baby is it? So the MIC is an EU baby, we know. And to me, this is not a problem, and it should not be a problem. Really had a debate, but let me just put out an argument out there. So indeed, one would note that if you're going to look at this from the 12 lens, so that's the third world approach to international law, considering the history and development of international law with respect to its colonial legacy, racial hierarchy, and oppression, then the cautionary approach to the MIC as a minimum is well understood, and that one could appreciate. I grasp a bit of this in the papers, and I also sense this when you engage colleague African delegates, particularly when there is a constant rejection to really address the African concerns, to get into the substantive issues, with a heavy reliance on the mandate argument, where this is not within the mandate of the Working Group 3, which I think it's purely artificial and self-serving. So it's an incorrect interpretation of the mandate, but of course we work on the basis of consensus. So it's difficult to, even though there might not be a correct application or interpretation of the mandate, you need everyone to agree to proceed. And so agreeing to proceed on compensation and damages was quite a success in that regard. However, when you look outside of UNCITRAL, so you look at the United Nations, we are currently negotiating international legal binding instrument on marine biodiversity of areas beyond national jurisdiction, so in the high seas and the international seabed area. One could say that was also an EU baby, but when you look at the text we're negotiating now, and you look at the engagement, it's really, it's taking on a universal character. So on the basis of the Multilateral Forum, it can no longer be called an EU baby. And so the question that arose yesterday as to why did the EU take the MIC concept to UNCITRAL? And I would think the answer largely is that of legitimacy. If you want legitimacy in reforming ISDS, then you need to take it to a multilateral forum where you have, of course, pluralism, diversity of views, but of course you have 193 states that could participate in the proceedings. And one could say the same thing for the intergovernmental talks on global tax policy, which is to lay the foundation for a new UN tax convention. And this was proposed by the African states. It was voted on by the United Nations General Assembly just 2 days ago, and this should lead to a new UN tax convention. The OECD countries wanted to keep this under their control. They had the initiative for a number of years, but they failed to address the issues, and developing countries also wanted now to monitor, evaluate, and decide on the global tax rules and shift the discussion to the United Nations. And so the African group proposed a resolution which was voted on. And even though you can call this an African baby, what certainly you will see in the years ahead is that the OECD countries will participate, despite their proposals fail in terms of amendments that were submitted. Participation would mean influencing, perhaps taking control of the process, but also influencing the outcome. So I see the same for the MIC. So it may have been an EU initiative, but eventually participation will lead to framing what will be the outcome of the Multilateral Investment Court. And this is a good point to turn up to the proposal on the Multilateral Investment Court. In addition to the EU, Sierra Leone has been one of those delegations that has expressed clear support for the MIC. And we see this as a key component of the deep structural reform of ISDS and the structural reform option. So further to all of the arguments that you've advanced in your papers on how a permanent multilateral investment court can address the systemic concerns of the lack of consistency and coherence, predictability, correctness of arbitral decisions by ISDS tribunals, and those pertaining to the arbitrators and decision makers, cost and duration. We had a particular specific consideration, And that is, and I think I saw this in one of the papers, that is the inevitability argument. Eventually, this is going to happen. And if it's going to happen, it's best for you to jump in and shape it rather than, join later and complain. And so this has been a major consideration for us to jump in, but also we got our first ISDS case during the process not too long ago. It has been resolved, but then it was a good way to say, well, this is important, and so let's get involved. The thinking is simple. It's happening, as I say, anyways, and perhaps the best approach is to engage early and influence its framing. As you know, we have CETA, EU-Vietnam, EU-Singapore, and EU-Mexico agreement. The investment cost system path is inevitable if you're going to do business, if you're doing business with the EU or you continue to do business in the EU. And you also have to acknowledge the power imbalance and how BITs are concluded. So from that pragmatic perspective, it's important to get engaged at an early stage. And that is in addition to all of the arguments you put forward from a normative point of view. From the high-level political engagement, it may be noted that the heads of state of or government of member states of the African Union and the European Union met for the 6th European African Union Summit in Brussels early this year, that's in February 2022. And under the Prosperous and Sustainable Africa and Europe joint venture, the leaders announced an Europe-African investment package of 150 billion euros that will support a common ambition for 2030 and the AU agenda of 2063. The investment package, and I repeat, investment package, will help build more diversified, inclusive, sustainable, and reliant economies. The investment package aims to boost public and private investment in several areas, from energy, transport, digital infrastructure to health and education sectors. And I quote, to implement the package, the EU and the AU will leverage public finance to stimulate private investment by mobilizing innovative financing instruments. When you go through the outcome of the summit, it tells you that this is leaning towards one direction. Eventually, you'll be faced with the Multilateral Investment Court, or the ICS, as was described initially. And so it's again reinforcing the view that it's important to jump in early and shape the outcome. So from the reading of all this, from a high-level meeting, I know that this is headed towards the ICS direction in the long term for ISDS, and therefore one cannot ignore the path a partner has clearly opted for. Therefore, for Sierra Leone, as we've reorientated our foreign policy approach to economic diplomacy, pursuing pragmatic policies, so this is realpolitik, becomes highly relevant. As such, and as we agree on the need for structural reform and appreciating the normative and functional value of the MIC, the pragmatic approach is to influence its features and characters. Therefore, my delegation has approached the negotiation as a mission to address Africa's specific concerns, ensuring we have features to address such concerns, whilst also ensuring we have a robust, sound, and effective MIC, one that addresses the systemic concerns that will basically affect everyone. So let me just now get into the features of the MIC, and looking at the time, I think we're still good. You were very generous, Martin, with the time, so I think we're still good. The features of the MIC. As was hinted yesterday, there is no need to reinvent the wheel when it comes to a permanent international judicial body to deal with investment dispute. Therefore, the features of the MIC are borrowed from existing mechanisms. Legal transparency certainly much alive here. Some of the features were introduced by Colin yesterday and elaborated upon today by Madam Secretary. A two-tier system, one with a first instance and appellate mechanism, full-time salaried adjudicators appointed by the treaty parties, high qualification and diversity, robust appointment process, an advisory center, transparency, third-party access, and an open architecture. I need not go into the details since a lot has been said on this already. As the working group 3 proceeds with its work, my delegation has applied the African lens to the working papers and the notes by the Secretariat. And I'll give some example before going to some of the features that I want really to test in the room. When we're looking at the note on the standing multilateral mechanism, selection and appointment of ISDS tribunal members and related matters, on the draft provision on jurisdiction, this has been really a topical issue also for the Code of Conduct. We've advanced the view and made the case for a broader definition of an international investment dispute. In our view, this should cover and capture all forms of investment disputes, so treaty-based, national law, and contract. Of course, there's interest also for states to state, but then we get the mandate issue. But for what we can get into the Code of Conduct and of course, the standing mechanism, this broader approach appeals to some of the concerns that have been raised by the African delegation. On the draft provision on tribunal members, we've called for substituting diversity, which was used, and really that's the conceptual idea that we have to improve diversity in ISDS mechanisms. But we've now gone for a more concrete principle, that is the equitable geographical distribution. This is the principle you find particularly in similar bodies, but also within the United Nations system. This is a concrete principle and can easily be applied with a minimum mechanism or maximum mechanism per region. And this is how you're able to improve diversity in a more concrete sense. This is a tried and tested principle. And in the International Criminal Court context, this is linked also to the issue of ensuring gender balance. I think the ICC is the only international court now with equity or equal balance of male and female judges. So this is something you can borrow from, and this is what we want to see in the MIC. So we've gotten into the concrete principles to ensure we get really what we want, and not just in examining the possible services which the center may provide, looking at the two pillars. So one, assistance in A, mediation and other alternative dispute resolution methods, and B, organizing the defense and support doing dispute settlement proceedings, and two, a forum for sharing of best practice, including pre-dispute and dispute avoidance services, mediation and other forms of ADR, as well as legal and policy advisory services. Sierra Leone and other African delegations that took the floor in noting the fundamental nature of the advisory center in the structural ISDS reform, supported really retaining the two. So, I mean, the two are not mutually exclusive. You can have the advisory service and advisory assistance, and also the forum for the exchange of information. This is also just taking on board the views of African states to have the assistance mechanism in terms of assistance support, but also the opportunity for the exchange of information. And you know, a lot of questions arose on the issue of funding. And so what we said that and there may be merit in looking at the evolutionary approach to address the financing question. In pursuing both pillars, the preference is to keep the two, but then in operationalization, an evolutionary approach may be considered. So depending on the financing, we can start with the forum of exchange, or you can start with an assistance mechanism, but we need to keep it the two. And this may seem like a simple argument, but it took us a couple of days to really clearly get to a path of saying we can actually have it too, and then look at how we adopt approaches to deal with the financing question. As an assistance mechanism, we further express our comfort with the draft provision that included representational service, recognizing the different approaches to representation and the availability of 3 possible service models as a menu for the requesting beneficiaries. So that is facilitating, supporting, but also representing. So I need not make the point that these views were not shared by all, and the discussion has not been easy. But then to just make the case that the concerns, particularly from the procedural perspective, are really being addressed in a more pragmatic way. So in the text of the negotiations, even though you might not see this in the proposals, and default, the fact that the proposal was an EU proposal does not mean you end up with an EU MIC, but rather a multilateral universal court if all of these ideas are taken on board on the basis of the consensus. So I'll go to some of the specific points which I really want to raise. So some of the thinking on how we can further address the concerns. And one really touches upon the issue that has been discussed this afternoon, location. We've had some interesting suggestions. But the thinking, at least from my perspective, is one way to meaningfully improve accessibility and diversity may require a decentralized approach, so a decentralized system for the multilateral investment court. And this could be similar to what you have as the internal system for justice for the UN staff, and specifically the United Nations Disputes Tribunal and the United Nations Appeals Tribunal. So two-tier. The UNDT is an independent tribunal. It's one tribunal, but with 3 locations: Geneva, Nairobi, and New York. There are 9 judges in the UNDT, 3 permanent judges, and of the 3, in situ in each is 1. So Geneva, Nairobi, and New York. So we address the Lomé and Abuja or South Africa question, and we can look at how this can work. The United Nations Appeals Tribunal was established by General Assembly resolution in 2009, and it's the second level appellate tribunal. It reviews the decisions of UNDT within the international justice system. And essentially, the point to be made here is that it functions as a court, independent court, with judges, lawyers, with a legal aid system. They go through the normal deliberations, and of course, decisions are rendered, and they can be appealed. And there's a registry. There's a principal registrar, and then you have the registries to support the three locations. Now, when you look at the current system for international courts, so you're looking at the Hague, the ICJ, ICC, and the PCA, Hamburg, ITLOS, and you can even call Paris with the ICC for arbitration. They developed a service sector, law firms, lawyers, universities. So the idea of having this location is to really drive that diversity. So it's not just the diversity in the appointments of the adjudicators, but diversity in developing capacity, developing this service community. Not just because if you were to put this in the Hague, then of course you say economies of scale, it's easy for you to operationalize because you have law firms, lawyers, familiar with international law. But what you'll be doing is to deprive development in the centers in, I know now we have centers in Rwanda, Lagos, so Kigali, Lagos, even in Cairo and other places. So it'll be a healthy competition to have a center using this model. So this is a thought. We have not gotten into this issue yet in the negotiations. So I'm happy to receive comments and feedback on this. This is just, bouncing off ideas. I see Colin, you're smiling, so we'll talk about this. So the next point, which also deals with accessibility, is really first looking at the services which the advisory center could render. I think I've talked a bit about this, so I need not get into the details on the services, but also it's the representational aspect and attendant cost. So this is a big issue for developing countries, including African states. And the point to be made is that if the assistant mechanism is going to provide assistant representation, then there could also be a further enhancement of this. And this is one point we also don't need to reinvent the wheel. On the issue of representation, lessons could be learned from the international court. So the International Court of Justice, the Permanent Court of Arbitration, and the ITLOS, the International Tribunal for Law of the Sea. They all have trust funds to assist states with limited financial resources to defray cost of litigation. Just using one example, using the ICJ in 1989, with a view to encouraging states to submit their disputes to the court, the Secretary General of the United Nations established a trust fund to provide financial assistance in certain circumstances. So this fund is open to all states, so not just developing states, but it's open to all states who wishes to submit a dispute, provided that the jurisdiction of the court is no longer in question. So you have to address the admissibility issue and jurisdictional issue. A further purpose of the fund, and this could really be interesting and important, a further purpose of the fund is to help state parties to a dispute to comply with the judgment rendered by the court. So also this component of complying with judgment. The trust fund was introduced as a device to overcome financial impediment to judicial settlement of disputes between states by offering financial assistance in bringing the dispute before the ICJ. The trust fund could also, in the context of ISDS, it could be a counterbalance to third-party funding. I know this is an issue that we're discussing, but this is an interesting way to look at it. But I am not going to open this kind of worm just yet, just to throw in the ideas for now to say that we have this in other international courts and tribunals. Now, in terms of capacity building, so in addition to having a decentralized vocation, it is interesting to note that it's just in 2020, quite recently and really, really late, a trust fund for the Judicial Fellowship Program for the International Court of Justice was established by a resolution of the General Assembly. I know some of the scholars may be familiar with this, and maybe you wanted to go to the ICJ to join the program, but your university had no funding to basically second you or send you to the ICJ. Now, what this, and this issue is really about equity, to ensure that firstly you can have universities and international institutions to send in their students to work with judges. Now, the resolution will allow for an increased participation for law graduates, particularly from developing countries, because this will also defray the cost. And so if we were thinking of an MIC, if we were looking at addressing this issue of diversity, capacity, these are things which really we can weave into the system, whether it's in the establishing treaty. And this addresses some of the concerns we've identified in the working group. So maybe I'll just quickly move on to an issue which I tested yesterday, advisory opinion, because the frustration for most African states is really dealing with the substantive matters. And as much as I will want I think I'm saying this for the third time, as much as I would like the International Law Commission to look at this, I do understand the explanation has been given, and maybe it's not the best route. Maybe it's for states to take the initiative, and then the tribunals will follow the leads of state. But an important tool in terms of clarifying international law has been advisory opinions. In what seemed to be the collective frustration on the remits of the mandate or lack of appetite to get into substantive standards, perhaps in agreeing to the argument on how a permanent investment court can address the systemic concerns on consistency and correctness, rendering advisory opinion can be a useful tool to provide substantive guidance. As we know, and again, I'll go to the ICJ because it's a good example of how they've used advisory opinion to shape international law, whether it's in legality and the use of use of force, nuclear tests, decolonization, and including the very last one on the Chagos advisory opinion. It has been quite useful, and this is a core function of the ICJ. So the General Assembly, based on the UN Charter, Article 96, could request an advisory opinion. So in contrast with its dispute settlement function, where the ICJ decides a specific dispute between two or more parties, in the exercise of its advisory function, the ICJ clarifies what international law requires on a given question and spells out the relevant legal consequences and obligations. Advisory opinions of the ICJ general statement, as you know, regarding the state of international law on a given question, but a command tremendous legal and symbolic authority. ITLOS also has the provision for advisory opinion, and its advisory opinion on liability has really shaped the negotiations on the mining code. So could be something of importance for the ISDS context. But then I was reminded yesterday of the challenge of dealing with 3,000 BITs. So how would a multilateral investment court deal with these issues, deal with an issue of having 3,000 BIT and offer advisory opinion on the substance? Could this be a request by the two parties? So they will not submit a contentious dispute, but agree to request for an advisory opinion for clarity, or is this something which a conference of parties, notwithstanding the existence of 3,000 BITs, could request for anyways for clarity on an issue where we think the jurisprudence, if I may, in terms of the decisions of the arbitrary tribunal is really split. We can get to the issue of the definition of investment, and this is something you can ask an advisory opinion. And the advisory opinion of the MIC could be quite authoritative in that sense, and will guide future panels. The last point I will raise is really looking at linkages with the United Nations. I think it's also an important component that the MIC eventually, and I'm saying the MIC eventually because we support the MIC, would have a linkage with United Nations. And this is also not new, and this could be in the form of cooperation agreement. This is essentially to ensure, firstly, political legitimacy, also transparency in participation, but representation. The United Nations is the only international organization where you have at least 193 states, but also in New York, you have all of them represented. So if you're going to deal with the issue of calling a meeting of conference of parties, as the ICC is doing, at least meeting in New York once every 3 years, and also when they're taking major decisions, including election of judges and prosecutor, you see that it addresses this issue of potentially a deficit in representation, because once the conference of parties get to meet, they will have to decide on, they will have to work on and agree on subsidiary instruments. A lot also could be gained or lost there. And so the issue of representation is important, and for the MIC to keep its legitimacy. This is a formula used, as I say, by the ICC and ITLOS in terms of the state parties, the meeting of the law of the sea annually. So I am going to conclude, but then I should note that I have not addressed the procedural reform options, that is from early dismissal, security for cost, allocation of cost, counterclaims, third-party funding, and participation, simply because in the discussion on those, the views from African states are quite, I think we've been quite vocal to say these are important to address some of the concerns, and this is already part of the mandate of the working group. But we were here to talk about MIC, so I don't want to spend too much time on those procedural options. Let me just say that I wholeheartedly agree that improvement in the procedural framework would be desirable, and there are various ways in which this could be done, and I think the Secretariat is doing an excellent job in providing us the helpful working papers to move forward with our discussion. Let me also add that at this last concluded session, for the third session of the working group, we discussed the issue of identifying other cost-cutting issues that could be addressed under the auspices of the procedural reform, in addition to those issues that are already contained in the working papers. I will not give you the numbers now because that would take a bit of time, but what I can say is that at the close of the discussion, the Secretariat was requested to prepare a draft provisions on the issues, including damages and compensation, considering recent treaty practice, but also the amended ICSID arbitration rules, as well as studies conducted by other organizations. Now, in terms of the African group, African state parties, member state participation, we were able to really convene, meet, and discuss in looking at this stock-taking exercise. We were actually able to agree on what could be requested. So we agreed on text, but there was no political agreement to submit, to make the submission. It's quite challenging, as I say, but this is really some of the things which are contained in the agreement. And so it's good for me to read them out. So you're also aware that the issues which you have raised are also being considered by the African delegates. So one is reaffirming and protecting the state rights to regulate and to ensure developmental goals and principles of basically sustainable development are provided for, and looking at recent treaty practice. And we cited in Morocco, Nigeria, BIT. Also to look at carve-outs and exceptions to limit the scope of dispute settlement provisions to investors that do not follow requirements of nationality, or who have not made substantial business, who have no substantial business activity in the territory of the host country, or who do not comply with laws and regulations of the host countries. So we wanted the Secretariat to do a bit of work on that. So provisions to allow recourse to domestic courts and jurisdictions is not exhaustion, but recourse to domestic courts. Deference to judgments of the highest domestic courts and jurisdiction of host states. Strengthening and broadening the role of state-to-state mechanism for the settlement of international investment dispute. And finally, opening dispute settlement proceedings to communities or interested parties, extending the correct scope of third-party participation. So that's also part of the discussion we've had. So this gives you an idea of what we've been doing, but then I've listened to you patiently because it's important to also have feedback and ideas. And so this has been most useful for me. So finally, I hope I've not bored you with an almost UN style statement, so there's no presentation. It's like, let me use UN style for once. And still doing, I've not ruined your experience for the 2 days, but let me just thank you for your attention and really extend my very best wishes to you and your future work. Thank you.
I think some questions and answers have to be in order. That's okay.
I was going to say question and answer was not part of the deal, but yeah.
All right, can we negotiate? Can I just make a quick framing comment at the beginning? How wonderful it is that you're so transparent regarding your position with regard to the idea to create a multilateral investment court, because many states, I noticed at the meetings, hold their cards very close to their chest, which is legitimate, but we're not talking about war strategy here. You'd think if you put a proposal on the table, some people might think, well, say, oh, I'm more or less open to it, but I want to see changes. But the fact that you're so wonderfully transparent about it is really nice. Like my own home country, Australia, I don't understand their behavior sometimes. Please don't mention that to them. Well, did you see what they did to Novak Djokovic when he tried to get it? The borders are quite difficult to pass through. So, yeah, that was wonderful that you also, sorry? Oh, God. And other countries you see, like a particular Middle Eastern country, well, Bahrain, I'm reading between the lines. It seems to be that a very prominent arbitrator advises Bahrain exactly what to say. You don't have to comment on that, but the fact that you're so transparent is wonderful. That's it for me. I'll kind of go around and start here with Marc.
Thank you. Yeah, just your issue transparency. Isn't this what we should have learned from the past 10 years? And what we should ask from all players in the room, that they position themselves, they put on the table their actually ideas, be it invisible model BITs, making them visible and so on. So this is what we need. Otherwise, we're going to have the same backlash again. I mean, it is not rocket science what we're discussing here. It is not top secret, but it is policy making.
Okay, so thank you to the ambassador for this very insightful presentation, even if I was not here at the beginning. So I don't know if the point or the question I'll try to make has been addressed before. In my view, I think a lot of frustrations that African countries are having vis-a-vis the current system is coming from the perceived inability for them to participate sometimes in the settlement of the dispute. And in this regard, we are having this excellent proposal, the establishment of the advisory center. But my question, but we all know that also this center cannot solve all the problems because of financial constraint and in terms of case management, because we are talking about more than 50 cases per year. And when I was looking at the submission of many African countries, they were complaining about the fact that they cannot fully participate. And now my question is, why do we need an outside or maybe a solution from outside? If we have identified an issue, why not coming with maybe a continental or a regional solution to that problem? I'm putting here because you are the one who is in front of me right now. And yeah, so maybe I would like to have your thought about this topic.
Thank you very much for this presentation, maybe more a comment than a question. I was particularly intrigued by the parallel, or I understood rather the inspiration you want to draw from the UN Dispute and Appeals Tribunal. And I noted that in a way, it inverses the current plans that we have with regard to arbitral tribunals as a first instance and a permanent appeals mechanism, because one shouldn't forget that it is the UN Dispute Tribunal where you have permanent judges on the first level, and then you have more or less a, I wouldn't say ad hoc, but you have the appeals tribunal with professionals who have various jobs and who come, I think, 3 or 4 times a year to hear the appeals. That is noteworthy. I'm not commenting any further whether I think it's the preferable or not, but it certainly goes against the mainstream thinking that we have currently.
Okay, my question is, might be tricky and you don't have to answer it. Without kind of baiting you to reveal any kind of our diplomatic discussions, why couldn't the African group submit, or why was there, what was the reason that the group couldn't submit its recent texts?
Thank you very much, Mr. Ambassador. I just have a quick question. Is there an African position as to who should be the beneficiaries of the services to be provided by the advisory center? In particular, should it be limited to states or should it extend to private actors, the claimants?
You mentioned earlier on in your speech that you've noted that there are some difficulties with even getting consensus and agreement on some issues, even within the African Working Group itself. I was wondering if you could share what some of the most contentious issues that have come up, especially in relation to the Multilateral Investment Court amongst the African Working Group members.
I'm going a bit on tangent here. I'm not sure if it's your area of your knowledge there, but perhaps my question would be, what would you find to be the difference in approaches to finding consensus and discussing issues in Working Group 3 as compared to the discussions on the African Continental Free Trade Area, or maybe in particular the investment protocol?
I think that's it for our questions and comments.
Well, for the last intervention, I think I was able to keep you up. So it's good to get this quite good number of questions. I'll just try to run through them briefly, respecting your time, of course. Why not a regional solution to the issues being discussed in Working Group 3? And I think one would reason, and that will immediately reason and ask whether we're dealing with just a regional problem. I think it's a problem that goes beyond a regional concern. But certainly, I think a regional solution could influence whatever that is we're doing in Working Group 3 and also in the international context. This is tried and tested on many other issues at the UN. The difficulty is that on this economic issue, states have quite used to approaching issues individually. We don't have a competence for our regional organization to address this concern. So Colin is negotiating for the EU. He has competence on the basis of the Acceleration Treaty. We don't have the same for the AU Commission, for example. And so the Department on Trade is invisible in this. The FCTA is also invisible because it's quite an inception stage. So on the substantive issues, we can try to look at finding regional solutions because it's still out there. And I'm sure those regional solutions could influence what is it that we eventually will do in the international context. But of course, happy to discuss further on this. I note the comment, Professor Reinisch, on the inversion. My appreciation of the two-tier system, and perhaps I've been wrong in all of this, is really to find a sort of the permanencies at both levels. It's not just at the appellate level, but these are issues still being discussed to find the right model that will work for everyone and those who support the system. But even if we were to use the current thinking, I think it even would work even well in the context that investors that will have a claim against African states can easily proceed to the centers that we have, and then we have the permanent mechanism. And one of the risks is really the issue of coherence and correctness of decision. But I think that's where the role of a very strong registry in shaping and ensuring that there's procedural integrity, but also the review that the appellate mechanism will do. So for me, the problem really is how do we address the problem of diversity and building capacity in developing a legal sector without really risking correctness and coherence. So those are the things which we have to look at, and whatever would work well in this model, I think should work well for everyone. And so we don't get to vote on Paris, on Lomé, or whatever city that we have in mind. On the advisory, the interesting question is the reason why we could not submit. I think a fair response would be time. We discussed the cost-cutting issues in the room, and we really spoke with one voice, getting damages and compensation on board. And then we were asked to basically go through the working paper and look at other issues which we could add. We added a fair bit. And there was also quite a good, you could say, convergence in terms of views of African state. But when it came to the additional submission, the paper was done right there in Vienna. Substantively, we were fine with it, but then we have to go through the process of instructions from capital, getting political agreement for a submission. So it's a formal document. It's going to contain the name of the African delegation. So it goes beyond, even though we have high-level representation in Vienna, but you still require some form of concurrence from capitals. And so that was one pragmatic issue. Generally, of course, we still have to coordinate on the specific substantive issues that we negotiate. Since we're still working on this coordination mechanism, it's still difficult to have a sort of an automatic submission. Because once we agree on position, then it's easy to submit without going to requesting for approval from capital all the time. So we still have to do this organizational challenge. We have to meet that, and that is a headache I have to continue to think about. Advisory Center. So I think the focus on the discussion firstly was on the services, and the immediate beneficiary one will think of states, developing states particularly. But then we've seen case being made for SMEs, and as part of our submission, we had this issue of local communities. So what we think that once we're able to agree on those issues, then it's easy to identify who the beneficiaries will be. But we're certainly coming from a state being the primary beneficiary point of view. I have to run because I know time is an issue. Difficulties with consensus. And I think it goes back to coordination on substance. Until we're able to coordinate on substance, it's very difficult to reach consensus on those issues. Differences in working group 3, and thank you. but please don't go without me thanking you and the work that you do in the Secretariat, particularly in encouraging participation from the African member states. Thank you so much, and have a safe flight. Yeah, I think best. Perhaps just to make the point, between AFCT and Working Group 3, I think it's really a question of transparency. We have to be fair. The mandate of Working Group 3 is to have, well, it's still government-led, but it's broad discussion, open, and you have everyone in there. It's not the same for the AFCFTA. I mean, we're only looking at the document now because it was leaked. And so there is no this broader engagement. As was said, this is really a policy issue. It's not really developing a nuclear weapon. So there should be broader engagement in this. And then you leave, and I think this is what is missing in the understanding in the lawmaking process at the international level. So you can engage broadly, including with academia, civil society, encourage development of ideas as much as possible, and then you leave decision-making to the political actors. But what we're missing now is that engagement that will inform decision-making by the political actors. I saw the protocol again for the first time yesterday, and I've been asking, including because I'm not a delegate. We don't cover the AFCTA. So I have been asking my representatives as to where is this document, because I want to reconcile what they're doing with what we're doing in Working Group 3, and I only got it yesterday. So transparency is one big factor in terms of the differences in approach. Thank you. Okay.
Yeah, I think that's pretty much it. Jonathan, our host, has represented a bit of an inconvenient time, but that's okay. Thank you, Michael. Again, that was wonderful. We just wanted to finish with a couple of closing remarks. Emmanuel might help me as well with this. The funder obviously pays for the workshop, but then they also want scientific results, which is not only talking about your research, but of course, if you can put it in printed form, this is what they absolutely love. And this is ultimately our goal, is to have all the papers published somewhere. Exactly where, exactly how we do it, we need to think about that, because you can see that they cover a diverse range of topics, and it might not be possible, for example, to put them all into one edited collection, for example. So we need to think through what is the best way to move from this point here, where you have feedback on your papers, to the point where they are published in either a journal or edited collection or wherever. So that's the plan going forward, we'll just have to be in touch with you. I suspect we might have to have a few Zoom meetings to nail out some of the details, but that's the plan going forward. I have a couple of other things to say, but I asked Emmanuel, did you want to add anything to that?
I think that's about it. We'll have a meeting.
Yeah.
We'll come back to
Yeah. One other thing is, there is no workshop dinner this evening. The fund will only pay for once. That's unfortunately out. However, I did notice there looks like there's a good restaurant a block behind us at the hotel. And I thought if there's some interest, we could go up there at 7 o'clock, say, have a meal and then come back. But we do have to check the security situation if it's possible to walk around there without any issues. So I'll come back to you on that via email. If you wish to join, you're very much welcome. Otherwise, I think we can wrap it up now and we can take the bus back. Are there any final questions?
Actually, one of the things that some floated around is whether it would be a good idea to have, like, mostly at least, but subject to you can reject if you want to, but put ourselves in order to be touched by email. So like a list.
Yeah.
And so what we'll take is that you probably opt out if you object. If you don't get an objection from you, we assume that you consent to your email being passed to others. We'll look at we respect your privacy, so some emails that were sent before we made it BCC, which means that you don't see each other's name. So we wanted to make sure that this will from separately. So we'll give up to one. If you don't get objection, we assume that you
We'll give you 1 week. That's enough time, I suppose. Conveniently, Jonathan has just walked back into the room. We're just closing up. Is there anything that you wish to add?
Lots of thank you to sure.
Yeah.
Really, everyone coming and participating. And after who speaks country, lots of energy. Just appreciation.
I think it's a right department. Yeah, that would be good for the funder. They'll believe that we actually came together.
We suggested letters. When they were here.
That's true. We'll have to Photoshop.
Yeah, I took up my book.